Okay, how's everybody this morning? 42 of you so far in this class. Okay, question. Okay, yeah, we should start with some questions, right? Okay, so what do we have? A question about EPE. Just received a debt on the test day. Your debt should be clear of any non-permitted material. Which books? Electronic books, I guess. I just don't see why you would not be allowed to maybe a book by D.H. Lawrence, something of this sort. I don't know. I've never heard of this one. Okay, because you're entitled to all the. Okay, someone signed as our agents. Are they just bound by the code of ethic or any other regulation that we are bound to do as well? The agent regulation that you need to be familiar with, and they will be bound with the contract you will have with your agent. Okay, so you have the code of ethic, agent regulation, and your contract with the individual. Okay, so that's good enough.
Morning, Jerry.
Good morning.
Jerry, I had a question yesterday, and I think I misunderstood what you were trying to say. A further clarification on that when you said that a person who is like a foreign national, he goes to US and comes back, visa would not be. I mean, it would not be a reset for the 6 months, but
Yes.
it would be different for different nationalities. What I think. What do you think? I mean, what do you believe? If it's an Indian national with an Indian passport, would it be same as a American citizen with U.S. passport?
Okay, let's clear the I think the what I said. Any foreign national inside Canada that does not include a Canadian citizen or permanent resident. So any foreign national inside Canada with an authorization to stay in Canada that is valid until a certain day would, if that foreign national of any nationality who would enter the United States and return to Canada, that would not affect the date of the authorization to stay of that foreign national in Canada.
Irrespective of being American passport holder or Indian passport holder or any other passport holder.
Correct.
Okay, so it doesn't reset even by land or by air, both.
Yes. Let me try to find, I think it's 183. We'll try to find, I should remember this one by heart, but I don't. Let me see. Where do I find this? Just a second. Is this 183 or 190? Just a second. We'll try to find it. Statut de l'établissement temporaire. Let me see. Or is it 190? 190. Okay, it's 190. 190. I will find it. It's not very far. 190. 190. Okay, 190. 190F. So it's 1903F. Okay. Visa exemption. Okay. A foreign national is exempt from the requirement to obtain a temporary resident visa if they are seeking to enter and remain in Canada. Okay, so no need for a visa if you come to Canada. F, to re-enter Canada following a visit solely to the United States. And if the person has either a study permit, a work permit that was issued before they left Canada on such a visit, or return to Canada by the end of the period initially authorized for their stay or any extension. Okay, so this is where it says you go to the United States, you return, you don't need a visa because you already have one and you already have an authorization to stay. And that is the authorization to stay that is valid. So there is no new stamp or no new authorization to stay because you already have one.
So it would
And
not.
that is for any. It says here, who is any, any who? Any foreign national. So that includes an American, an Indian, a Chinese, or a French citizen, and so on.
So it would not reset. It is like it would be considered the authorization to stay if it's for 6 months, 3 months you stay and then you go back to US and come back. It will not reset the 6 months. It will be.
Exactly. That is because you re-enter Canada either from the United States
Or
or Saint-Pierre and Miquelon.
clear. Thank you.
You're welcome. Okay. Let me see. I have a question here. So just a second. Okay, let me see. I noticed yesterday that the HNC was not posted. Would you be able to post it? Yes, all PPTs, are will be posted eventually. Okay, not to worry, but they're not necessarily posted 5 minutes after 4 hours of teaching. Okay, so a little bit of patience. I've noticed it's true it's a big class, but every day you're asking me to post the material. So I do appreciate that you appreciate the material. It's quality material, I understand, and it will be posted. Okay, not to worry. What else? Question R26. No other means of support. Work permit may be issued if under unenforceable removal order. Is this only referring to refugee or the other example, or any unenforceable removal order? Anyone who would be issued a removal order for criminality, misrepresentation, and so on, and who could not be removed from Canada would be under an unenforceable removal order. Okay, and therefore, instead of leaving the individual on welfare, we would provide him with a work permit so that the individual can keep busy, okay, and work and go for. Okay, so it's all foreign nationals with an unenforceable removal order.
Excuse me, Gary. I have a question for you. Can you shed
Sure.
a light? This is Shahram regarding unenforceable removal order. You previously mentioned it, but I want to specifically, if you don't mind, talk about that one different scenario that ends up with unenforceable removal order.
Sure.
Thanks.
Yes. Okay. So what is a work permit? Where is the 206? Yes. A work permit may be issued to a foreign national in Canada who cannot support themselves without working if the foreign national has made a refugee claim, or you have the or here, okay? Or is subject to an unenforceable removal order. So that is a foreign national who is subject to an unenforceable removal order. It's not A and B. It's A or B. So the refugee claimant may have a work permit, and the foreign national who is subject to an unenforceable removal order is also allowed to a work permit. Okay, let me see here. What do we have in French, for instance? Un permis de travail, si il fait l'objet de qui ne peut, yes. And that is for paragraph 1, there is also a condition that the refugee claimant has to wait 6 months before the work permit is being issued. despite subsection 1. Okay. In both cases, okay, so must not to a claimant referred to in section. Okay, so this is what we have here. Are you okay? So it is not.
My question is, which scenario ended up with to the unenforceable removal order? That's the
Which scenario?
yes. Which different scenario ended up with unenforceable removal order? For example,
Well, you could, for example, you could have, let's say you have a sponsor, a permanent resident, who would be sponsoring an individual, a parent, and who would be found inadmissible because of misrepresentation about the sponsorship, and eventually that sponsor permanent resident would be issued a removal order that would become unenforceable because we could not remove that permanent resident to the destination country for some reason. So then the removal order becomes unenforceable. And what to do with this sponsor, this previous permanent resident, who cannot be removed from Canada, but who is not a security risk as well. So then a work permit would be issued until the removal order can be enforceable.
Does this apply to refugees who are made inland instead of port of entry?
You mean the claim for refugee protection, the work permits, you're talking here of no other means of support. We're still with 206, right?
Yeah, let's say that someone who came in a visitor visa and then they applied for refugee inland at the center
Yes.
of the sea.
Yes. Yes.
So in this case, they are allowed to have a work permit, right?
Yes, exactly. 2061. This is what we have. 2061A has made a refugee claim that has been referred to the Refugee Protection Division, but it has not been determined. So then a work permit is issued as well. Yes. Okay.
Jerry, can I ask a quick question here?
Sure.
It's actually two parts. One is just to confirm, a TRP is issued for someone outside Canada, yes?
A TRP is issued?
For someone outside Canada?
No.
No.
Always at port of entry or
Correct.
Inside Canada.
Correct. But for the most part, it's for people who are inadmissible for one reason or another.
Yes.
And so you would apply for that situation while you're outside. You'd be issued it when you're in Canada, correct?
Yes.
Okay. So now the question is, just again, we're coming up with a scenario. If you have someone, for example, a permanent resident in Canada, been here many years, married, has children born here, commits serious criminality, gets sentenced to prison, 7 months, for example, does the 7 months, immigration decides that because of the serious criminality, he's subject to a removal order. He doesn't have a right of appeal because of the serious criminality, and he decides to apply for leave for judicial review. Now, my understanding is there's no stay of the removal order while he applies for the JR. And so two questions here is, A, how would he stay in Canada until the judicial review is heard? And assuming for whatever reason he is in Canada and is allowed to stay, when the judicial review occurs and he's going to argue for HNC, what is the ultimate result? Is it not a TRP?
Well, you cannot argue for HNC because judicial review is only a judicial review of why he was issued a removal order.
Okay.
And then if the federal court considers that the removal order is indeed legal and reasonable, then that's the end of the judicial review. The application would be denied, and then the removal order comes into force.
Okay, so the removal order doesn't come into force prior to the appeal leave for judicial review?
No, because that is the final determination. That is the judicial review.
And then where I'm just getting confused here. How and when, or is it even a possibility that he would apply for HMC? I mean, he's been convicted of serious criminality, so he has no right.
Yes.
So
Well,
would he apply?
he could apply for HNC the day he becomes a foreign national, the day he has a TR, the day the removal order comes into force. If that is not a failed refugee applicant, we're talking a former permanent resident, then he could file for HNC.
Where? That's the question.
In Canada, he is still in Canada. He could apply in Canada.
Correct, but with whom? With the IAD?
With whom? No, that is Section 25. You would apply for an application for permanent residency to stay in Canada as a permanent resident, being inadmissible. Then you would file an application with RCIC based on HNC ground.
Perfect, thank you. That clarifies it.
Okay. And if you look at 225, it says, yes, any foreign national who is inadmissible can apply for HNC. And the minister must examine the circumstances of that individual. And serious criminality does not exclude, is not excluded. Okay, that is interesting question. So just a second, I have many questions here. You have doubt on safe third country agreement. The refugee claimant rejected from USA can only make claims at the airport, but will not be able to make a claim if they apply after coming by land or sea. That is correct. Yes, they can make a claim at the airport, but they cannot make a claim at port of entry or sea. Yes, that is correct. Okay, that is for Canada. Or citizenship revoke and loss of PR and the person becomes stateless and cannot be deported is another example. Yes, correct. That would become an unenforceable removal order. If Canadian citizen parent work abroad as a crown servant and give birth, is that child a first generation? No, that child is not. That is the exception to the citizenship first generation abroad, because the parent are working, one of the parent is working for the crown. TRV might not work due to the T card cannot this. Judicial does not stay a removal order. Not necessarily, okay, that depends. Is having it makes a person not qualify. I thought is having exclusion order makes a person not qualify for TRV. Yes, that is correct also. I believe he says the exception and that just said not okay. What is the difference between judicial review and appeal in a federal court? There is no appeal at the federal court. Okay, there is only there is only judicial review of a decision. Now, if there is any appeal available, it's the legislation that allows an appeal to an administrative tribunal. That would be either the Refugee Appeal Division or the Immigration Appeal Division. And to challenge a decision, then it can be done at the federal court, but it is not an appeal as such. It's a review of the way the decision was taken. There's no appeal right. Are we going to have for the that are closed like interim pathway? No, there should be no question about a closed program. That is useless to test your knowledge about programs that do not exist anymore. So extremely unlikely. Question here, if the sponsorship application was approved, just a second, in principle, and right after the sponsor was convicted of sin, was issued a deportation, the sponsor will be denied. Yes, but would the sponsored person be removed as well? If the person has, there's two possibilities here. If the person is in Canada as a foreign national, the person remains a foreign national in whatever her status is, okay? And in yes, okay. If the person is outside Canada, well, of course, there's no issue. The person would the person being sponsored remains a foreign national, because so then there's no impact there's no impact on the person being sponsored if the sponsor becomes inadmissible. Okay. Excessive demand on adoption. There is, if there is an adoption, there is no excessive demand for adoption. It's the same as sponsoring your blood child, your biological child. So there is no excessive demand if you adopt a child at the international level. Is the rule that student can work full-time during only off campus or also on campus? It's anytime. There is no restriction about how many hours a student can work on campus. The restriction is only off campus. Okay. Okay, so a permanent resident under unenforceable removal order is still a PR and can still work in Canada. No, a permanent resident whose removal order came into force is no more a permanent resident. Okay, and is therefore a foreign national with a removal order that is unenforceable. Okay, so therefore that person would need a work permit with 206, 206, that's the one we saw a moment ago. That would be 206B, 1B, I think. Okay, finally, I say finally, this is the last question I have on my screen here. I am in Canada on a closed work permit Lmia for 2 years. My spouse is also in Canada with me on an open work permit. So far, so good. My PR application is in process under CEC class. I am being laid off. I am eligible to apply for a bridge work permit. Most likely, because you're laid off, you're still, I suppose, it depends where is your, because this was a closed work permit. Yes, I think so. You would apply and you would be under implied status until you get the bridging work permit. But would have to see the exact requirement for you to get the bridging open work permit. But my initial understanding would be yes. After judicial review, is there a higher authority who can appeal the Federal Court of Appeal? Yes. This is why certain cases will reach the Federal Court of Appeal or the Supreme Court of Canada. But to go to that level, the Federal Court, after a decision, has to register what we call a certified question. Okay, so this is how there is a possibility of appeal. The court, though rendering a decision, the federal court will say, but there is a question I would like an answer for. Okay, so that is the case here. For instance, with Vavilov, the famous cases of the two children born in Canada to Russian spies, the federal court asked a question, two questions. What is the standard of review? And the other question was, according to the Citizenship Act, employee of a foreign government in Canada. The question was, do they need diplomatic status to be considered as such? Okay. Then that gives a right of appeal and eventually reaching the court. Second example, Baker versus Canada, the federal court, the certified question was, does an immigration officer has to consider the best interests of the children when they're looking at an application? That gave room to an appeal and eventually the Supreme Court. Okay, do the question in the mock exam change in sequential order between exam takers? It should not. I hope not. Usually, let me check. I hope not. Sometimes the support staff at the college, they will change it. Let me check right now. Just a second. Okay, let me see the assessment. Okay, and let me see, just a second. I will just stop sharing. Okay, and we'll check the issue here, because then it's no fun for me when we review. Okay, assessment? No, there is no randomly a question here about exam 2. No. The question, no. Okay, so there's no problem. There's no, it's not a shuffle. Okay, they're all the same. All of you are going through the same order of question. Finally here, and if a refugee flies to the border from the US, can claim refugee at the Canadian border? Yes. Okay, unless the exception being, unless the person has filed a refugee claim in the United States that was denied and is in transit through Canada, then that person cannot make a refugee claim in Canada. That is the exception. Okay. Okay. Yes, anything else? No? Okay, not for the time being. Okay. Let me check. There's one thing I wanted to look at about the CUMSA. Okay, Canada, is this the one? How about this one? Is this the one? No, I want to look at Immigration Canada. That is an important Facebook word statement background there. Maybe, let me see. That is not a backgrounder. Doing business. Cannot find it. Because if we go to that NAFTA, okay, this one, sorry, am I sharing my screen with you? No, okay, I will share my screen with you so that, just a second, so that you see what I'm doing. Okay, maybe this one. Let me see what I have here. International Free Trade Agreement. Okay. And how about this one here? Yeah, that is the page for you to read. Okay, about trade agreement. We'll be looking at this in a moment. Okay, because you have here the various international trade agreement, and this is NAFTA, but there's no need to read it anymore, which is still the same. It's exactly identical for immigration purpose, NAFTA and CUMSA. Okay, so this we have, let's see, that is the mock exam. Okay. What else? Okay, the time is up for question, but I'm willing to answer one last question if you have one. Otherwise, we'll be looking at, we'll start with trade agreements, international trade agreements. So will be a couple of questions on this. Okay, there's always, just a reminder, safe third country agreement, there's always one question, maybe two. The question is always about the exception. The story is you have somebody coming to Canada at the land border and making a refugee claim. Can he not? Okay, and there's three possibilities, three questions so far. One is a stateless person who lives in the United States, who's been living in the United States quite a while. Can he? The answer is yes. Okay. The other question is the person has a family member in Canada. Okay, most likely, careful, most likely the answer is yes. The third question that was some time ago, a non-accompanied minor coming to Canada, Who left the spouse back in Central America? Okay, 17-year-old. Kenny, the answer is no. Why? Because the person is married. Okay, so those are questions about the exception. American stateless people can make application for refugee at the border. People with family members in Canada, almost all family members, well, the usual family members, okay, but have a look at the page about Safe Third Country Agreement and the unaccompanied minors. Essentially, those are the questions. Okay, you could have those who would have Canadian travel documents, visa, permit, and so on, but I've never seen this question so far. Okay, so this is one. Trade agreements. Trade agreement, the question I have seen, it's a little bit technical, but not that much. It's about after sales service. Okay, but let's have a look at those. If you're all set, am I sharing my screen? Yes. Yes. Okay. So I will move to this PPT about trade agreements, and essentially we'll be looking at what used to be NAFTA. Most of the other trade agreements are very, very similar, except for CETA, the European one. But questions are always, so far, 90% of individuals coming to Canada under the trade agreement are American. So usually the questions is about NAFTA, that is today CUMSA, but it's the same. There's no difference really for immigration purpose. A question here, for HNC, there is no appeal in any case, correct. Removal order won't stay, correct. And there is no HNC for 34, 35, 37, correct. And refugee claimant rejected has to wait for 12 months except for medical, yes, and best interest of children, and DFN must wait 5 years for HNC, correct. I agree. Okay, I agree with you. Okay, that is from our breed. So you're ready to answer 3 or 4 questions here. Okay. 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 Oh, and let's have a look at some international agreement. That is for the issuance. That is for yeah, great job. That it's all compressed. You know, it's all compressed within a few lines. Okay, so take a screenshot, all of you, and you're ready to answer a couple of questions at the entry to practice exam. Okay, international agreement. So 204 of the regulation. What do we have here? Just a second. I will just put here an R so that you know it's regulation. Okay, regulation 204. A work permit may be issued to a foreign national. Let me see here. I just want to make sure this is recording. I'm not the one to put this on usually, but yes, it is recording. Okay, it is. Where do you see this? Oh, yes, I see it. Okay, recording to the cloud. Okay, so that you will not ask me to do the thing one more time. Okay, so a work permit can be issued to a foreign national who perform work pursuant to an international agreement between Canada and one or more countries. So here we have a number of trade agreements, international trade agreements that Canada is part to, that would allow some individual to get a work permit. Okay, then we deal with agreement with the province and so on. But what we're focusing today are those international trade agreements. So there is a link where you can see the various trade agreements. As I say, most of them are sort of duplicate. The NAFTA is a sort of a template, okay, for many of the trade agreements. Let me move this also. Okay, well, we have questions on GATS. It's possible, but very, very, very unlikely. Okay. what we have here, we have CUSMA, I say CUSMA, Canada, United States, Mexico Agreement, that is CUSMA. There is GATS, General Agreement on Trade in Services, Canada, Chile, Canada, Peru, Canada, Colombia, Canada, Panama, I think. I'm not sure 100%, I don't remember. There's Canada, Korea, there is the Trans-Pacific Partnership, and there is, if I remember, there is CETA. Okay, CETA, and all these covered essentially 4 categories of people. Okay, 4 categories of people who could come to Canada to work, and they would get some privileges. Okay, some privileges in the sense that exemption of labor market impact assessment, for instance, even though they're coming for a specific employer. Okay, so for instance, expect influx of foreign workers, professionals under Trans-Pacific program. Okay, and we know that Mr. Trump withdrew from the US now that we have a different president in the United States. That may be different soon. Then we also have what is called CETA, the Comprehensive Economic and Trade Agreement, that is with the EU. This one is slightly different in terms of the duration of stay and who is covered by this. It's fairly quite different actually from the other. Okay, that is because of European requirement criteria. So let's have a look. It's written NAFTA here. I don't know if just a second. I don't know if I still let me see if I could. Is it good? Yes. Okay, so it's up to date already. Okay, it's the same. It's the same. It's the same. It deals with 3 countries. Okay, Canada, United States, and Mexico. And it is for, very important, it is for nationals of this country. Okay, so green card holder in the United States or other type of nationals in each of these countries are not included, okay, in those agreements. They cannot benefit of the same privileges. Okay, so it is about the NAFTA itself. Again, I have to update. That's an older presentation, but okay. What is okay? Okay, let's see here. It's an agreement between those 3 countries. It's about a free trade area, and it's to facilitate also not the cross-border of goods, but also I said, yes, green card holders do not benefit from this agreement. You have to have citizenship to take advantage of the various elements. Okay, so this is what we will see here. Okay, so it does facilitate. Okay, it does facilitate the cross-border of business people on temporary basis. So those are business individual. Also, labor market impact assessment exemption. There is no LMI required. There is also work permit exemption for business visitors. That is not exceptional. We see this for, it's already specified for many other business visitors coming from other country. Also, intra-company transferees, okay, that a person is moved from Citibank New York to Citibank Toronto, a banker, a senior executive, or a key people, and so on, then would get a work permit, without the requirement of a labor market impact assessment. Also, some of the privileges would be they can apply at port of entry as well. Okay, so there's no mention about dual intent. Okay, we remember dual intent, that people may have the will to become permanent resident, but also would come to Canada on a temporary basis. Okay, so definitely a NAFTA or CUSMA undefined temporary entry as entry without the intent to establish permanent resident. But I don't think there will be too much enforcement about a CBSA officer asking a banker from Citibank if he intends eventually to become a permanent resident. It doesn't matter. Okay, it's a matter of good faith. Okay, you could find, I understand that there is an extension under the new agreement about, it's a copy and paste from what I was told to the temporary entry for business person under NAFTA. Okay, so what do we have? Okay, NAFTA does not apply to permanent residents. Okay, so as I said, it has to be nationals. It does not change or remove any requirement to temporary workers. Okay, it does not change any requirement to admissibility. Okay, to admissibility, and also does not give any privileges to spouses or partners. Okay, so but Canada Colombia does. Okay, the agreement Canada Colombia does. Okay, let me see here. Okay, this is closed. Okay, so we have here 4 categories of people covered by NAFTA. Okay, business visitors. Okay, business visitors, they're people who come to Canada on a short-term basis. Employer and source of income remains outside Canada. Okay, they're individuals who come to meeting, they come to sell, they come to purchase, they come to speak at conference, or they come for training, to give or to receive training. Those are what we would call business visitors. So they can come to Canada and stay in Canada without a work permit. Those are the business visitors. Okay. Then we have professionals. Professionals, there is a list. I don't think you need to know the list. There is a list of 63 types of occupation. Okay. Are they coming? Would be granted open work permit? No, there's no, it's not about open work permit. The business visitor, they have a visitor visa. They can stay up to 6 months, okay, without the need to get a work permit, because actually they're not entering the labor market in Canada. As for professionals, there's a list of professions, accountant, engineers, and so on. They can, if they do have a job offer from a specific employer, they can get the work permit without the need of a labor market impact assessment. Okay. Same with the intra-companies transferees. Okay, a company is in the United States or Mexico, and the person is being transferred, will be posted, will be assigned for 3, 4, 5, 6, 7 years in Canada, also will be issued a work permit, a specified, a closed work permit, without the need of a labor market impact assessment. Okay. As for investors and traders, they're people doing business. They usually have a business either in Mexico or in the United States, and they wish to open an office, open a business in Canada. Then they will be issued a work permit as well, but some condition apply. The main condition that you could have at the exam, unlikely, but is that 50% of their turnover has to be within the 3 countries, United States, Canada, and NAFTA. So if you have, let's say, a Mexican company producing tacos, or I don't know what, then, and they want to, the owner wants to establish in Canada, will have to demonstrate that 50% of the business of that company is done among the 3 countries. Okay, that is one of those requirements. Okay, let's see here. So if there are any requirement for employer to provide a job offer qualifying the candidate, yes. Yes, the person needs a job offer, definitely. A university would invite a professor to teach for 1 year at Queen's University to teach Canadian immigration, and therefore that individual would be issued a work permit without the need of a labor market impact assessment. Okay, so that is one. So if they are, yes.
Sorry. I was asking about requirement for employer, not for employee. So the employer, do they have to satisfy any requirement to provide a job offer, or any employer can provide a job offer?
Any employer as we would consider an employer. What is any employer that would have been in business and would justify, to a certain sense, the existence of a space or of a position for that individual.
Okay, so IRCC will not look at the size of the employer and say no or yes based on the size of the employer?
No. Because as long as the individual being offered a job is a professional.
Okay, thank you.
Or meeting the criteria of what is an intra company. Okay, that there are some criteria to meet. Okay, what is a company, what is an affiliate, what is a branch, and what is the position being offered. So people from intra company, for instance, need to have worked for the US or Mexican company for at least 1 year. Okay, so that is a requirement, and they have to be at a senior level. Okay, so they have to be a senior executive, a supervisor, a manager, or what we would call a key people. So it's not designed for the clerk or the security guard. As for investors and traders, they're business people. Okay, so they're essentially business people. So there's some criteria as well to be met. Let me see here. So if they are professional and get work permit, then they can apply for PR. Yes, absolutely. Absolutely. If they can have within a year, they could meet Canadian experience class requirement. So there's no condition that they have to leave Canada and so on. So yes, they could apply and become permanent resident if they qualify. Yes.
Jerry, can I ask a quick clarification?
Yeah, sure.
This intra-company transfers, and professionals, etc., you can find it both in 205 and 204. So what is the difference? Because under Canadian interest also, there are intra-company transfers, almost the same kind of duration and all. How is it different from the NAFTA?
It's a different country. They could come from Malaysia, and that would be of Canadian interest to provide work permit for a team of guys setting up a huge plant of producing surgical masks for COVID-19 instead of importing from Malaysia, for instance.
Yeah,
so this would be under 205. That would not be under 204 because there is no agreement.
Yeah, but then I'm wondering. Oh, sorry. Then I'm wondering if a person can come from any country, then what is the benefit of this this particular NAFTA?
Well, the need is it's an incentive. People in the United States or Mexico can also apply, among others, they can also apply at port of entry, for instance. So
okay.
it is just because, not to forget, NAFTA and this, it's a trade agreement. It's not an immigration agreement.
Okay.
You see, but there is this section about how about people moving from one country to the other. Let's facilitate for the purpose of trade, for the purpose of business. That is the idea of 204 and those trade agreements.
Okay, thank you.
Okay. So yes, they can apply for permanent residency. They all need pre-arranged employment. That is correct. Okay, so adding a professional under CUSMA can apply for PR even after 2-3 months of coming to Canada, 2 or 3 months, even before that, if they meet requirement for federal skilled worker. But to apply under Canadian experience class, they need 1 year of Canadian experience, which would be most likely a NOx 0 AB. Right? But should they meet requirement for federal skill, anybody is free to upload a profile under Express Entry and decide to stay in Canada. Okay, so those are for professionals who get an opportunity to come and work, let's say in Canada. Will they want to shift to become permanent resident? That is up to them after that. But the idea here is to facilitate the arrival, the resettlement, sort of these professionals. They don't need labor market impact assessment. Welcome to Canada. We're helping you to have your job working in any place as a professional. Eventually, permanent immigration programs are available to them as well. Okay, for this, what else? So for instance, those occupation, actually it's 63 occupation now, okay. 63 I've read just recently, and it is 63, okay, but essentially, okay, so we're talking here professionals, accountant, architect, computer system analyst, and so on. Okay, and as I said, you don't need to have a list of all those 63. The scenario will let you know, or will let you believe that they are professional covered. That I have not seen tricky questions about, do you need what is profession number 62? Okay, there could be, we have other type here of professionals, so it gives you an idea: dentist, nutritionist, therapist, scientist, teacher, and so on. Okay, can their work experience be rejected because they're not supposed to pursue PR? Theoretically, yes. Theoretically, but it's not, they're not supposed to pursue PR. If they do not intend to leave Canada at the end of their stay. Dual intent is about, I don't believe you will leave Canada if you cannot become a PR. Okay, but to have the dual intent is not a fault in itself. It's not a sin. It's just that the officer has to be convinced that should the individual not become PR, though that is the intention, will the person leave Canada? Okay, so if the officer is not convinced, then yes, certainly an application could be denied, but that is, if we're thinking of those professionals, that is very unlikely. Okay, that is very unlikely. Okay, now for business visitors, there is no work permit. Okay, so this is their business. They're people who are on business. The essential component is that the source of income remains outside Canada. Okay, and it is a temporary stay for business, what we would call business activities. You would have the description of what we mean by business activities in section 186. What is a business visitor, and what do we mean by a business visitor? Okay, must be US or Mexican citizen. Business visitor can stay 6 months in Canada like any other visitor. Okay, it's a 6-month stay. They're on a visit. Okay, so for the others, so here we see the factors. The primary source of remuneration is outside Canada, and the place of business and actual place of profit remains predominantly outside Canada. Okay, so you have someone from any company coming to Canada for 2, 3, 4 months even is still on business. Okay, so for instance, myself, have been on business in many countries, sometime for 1 month, 2 months. But my source of income was never the country where I was, and my place of incorporation was never in the country I was visiting. So I was, when any immigration officers around the world will ask you, what is the purpose of your trip? You say business. Okay, and then they let you in usually as a visitor. Sometime you may need to apply previously for a visa, and then you will declare that you're about to come for business for a limited period of time. Okay, and it does not apply to diplomats, because there's two kind of diplomats. Those who come to work in Canada with diplomatic privileges. They're coming to represent their countries in Canada. So they'll be either in Ottawa or in some other consulate in Canada. So Immigration Act and NAFTA does not apply to them. Okay, but you do have some individual who come to Canada with a diplomatic passport. But those are, they may be given privileges as visitor, but that's all there is. Yes.
Again, this section 186 is not necessary to be a trade agreement, right? Because section 186 for all business.
For all business, exactly, exactly. And but you do have, this is what I say, you do have here as a business visitor to Canada within the meaning of section 187. And when you look at 187, it's the same definition of what is a business visitor. Just a second. Yes, the following foreign nationals are business visitors. Okay, and they buy, they purchase, they receive, they give training, they represent foreign business or government for the purpose of selling. That's about it. Okay, so this is what we mean by what is a business visitor.
Okay? Thank you.
So here I have, there's no Canadian subsidiary, can business visitors still come under this agreement for research purpose? For research purpose, yes. Yes, if the person, a business visitor, I don't know what research, they can do marketing research, for instance, preliminary trips to set up some business and so on. If that is what you mean by research, the answer is yes, absolutely. Anybody can come to Canada for a business reason. Yes, okay. Okay, what else do we have? So this we were saying, so for business visitor, so we have an idea. We may look at section 187. Okay, what do we mean also? Okay, by what is a business visitor? A reminder that it does not apply to permanent resident. In the NAFTA agreement or the CUSMA agreement does not apply. Also possibility to apply for the work permit at port of entry. Okay, supporting documents required, job offer, and so on. But everything can be done at port of entry. Okay, when the section 186 is applicable to all business, why they say it's restricted to US or Mexican citizen, the NAFTA agreement or CUSMA, for instance, application for work permit at port of entry is only people covered by CUSMA. Okay, so a Malaysian national cannot show up at port of entry and say, I want my work permit here. It has to be applied from Kuala Lumpur, for instance. Okay, so that is the difference here for the strictly speaking people. So if it is 186, we're talking about visitor. Okay, so then it applies to everybody. So it doesn't make much difference. Okay, I agree for business visitors. It just says, not to forget, the agreement is also the other way around for Canadians to go to the United States, to go to Mexico. And maybe Mexico or the United States may have a different view about who is a business visitor. Okay, so then here the agreement will define what is a business visitor, and that may be better for Canadians to be protected by this agreement. Okay, that may be the reason why also. Okay, so what else do we have? So after sale on the quiz, this is question you have in the usually you would have at the entry to practice exam. How about providing after sale service? Okay, there's two possibilities. One, you need the work permit, and you may provide later exactly the same after sale service, but you may or may not need a work permit. What's the difference? Okay, the difference is, okay, let's say we're talking of after sale, so you sold someone, or you sold something, not someone, someone. Okay, so an American company is selling equipment to a Canadian company. The Canadian company purchased that equipment, pays a price in Canadian dollar, and includes in the contract after sale service, training, warranty, and so on. Okay, so then the US national comes to Canada to install the equipment, and under the contract, they can come 3 months later, 6 months later to upgrade the equipment that was in the contract or to provide training and so on. When they return, they will not need a work permit because it's already in the contract. And the first time they came, they did have. But if it is not included in the contract, the same Canadian company signs a new contract to bring American citizens to work in Canada to install, repair, provide training, then they would need a work permit. Okay, why is it so? Well, it is says that the Canadian company is spending money, Canadian dollar, to workers outside Canada when it could spend those same dollars to Canadians. So therefore, a work permit will be required if it is a new contract. If it was included in the original contract, then a work permit shall not be required. Essentially, okay, if you look at the web page, you have a long description of what do we mean with after sales and so on. Yes, go ahead.
Sorry, Jerry. So a work permit will be required if it's not included in the contract. What about an LMIA?
Never, because it's NAFTA.
Yeah, Kuzma. Okay.
I said NAFTA. Yes. Okay. Yes. So there's then no LMIA in those cases. Okay. And again, work without a work permit also, that is for business visitors essentially, or after sales service. Okay, that would be for after sales service. So then they would need to provide documentations that they're coming, and they may not need a work permit because they're coming to provide training or repairs after sales service that were included in an initial contract, a previous contract. So how will CBSA know if the US technicians enter Canada that he want visit and then comes and work on equipment? Well, that is the purpose of CBSA, to ask question. Normally the CBSA officer will say, what is the purpose of your trip? And that is the duty of the foreign national, the American citizen, to answer truly. Okay, and says, I'm coming to repair equipment. Okay, and let me know more about it, I suppose. This will only be applicable to citizen. Yes, as I said, NAFTA or CUSMA applies only to citizens of the United States and Mexico. Okay, so even for 1 day or after sale, they may need open work permit. Yes, if it is considered they are entering into the labor market. Okay, so that is what is absolutely likely. What is the fixing contract is with a French company, then that is not CUSMA. Okay, so then we're exceeding our presentation today. Okay, or a Malaysian company and so on. So then that would be most likely, because there is a contract, I would believe we would have to look at CETA agreement if it covers those after sales service. I believe it does. I may have something here for you if you're interested by CETA, but as I said, very unlikely you will have question about the European trade agreement. Okay. Or UIWA, yes, or YWA, why not? Okay, so there, okay. So, so what is this? So here, okay, so this is the situation we often see also. It not only after sales service, but sometimes a Canadian company will sign a contract with an American company, let's say an American company, or any other company around the world. If the money is Canadian, so then that means the individual, though the employee of the American company, though being paid in US dollar by the employer, the US employer, is actually indirectly being paid by the Canadian company. The Canadian company is paying the other employer to bring the American staff to Canada to work. In those cases, a work permit would be required. You see, that let's leave it these two. I don't think you will have a question on this because it's a matter of interpretation, and we leave this to CBSA officer to determine if it's a business visitor or if it is a worker entering the Canadian labor market. Okay, so professionals, as I says, list of for now it's 63. Okay, list of 63 professionals are being identified so far. They're the most recent list. Okay, we're talking the condition, salaried employee, a personal contract, a Canadian employer. Okay. And as I said, there's a range of professionals coming to Canada if they need a contract, a job offer for this. Okay. Also, no LMIA work permit is issued at port of entry. Okay. As for intra-company transferees, the citizenship, again, US, Mexico, and the employment is an executive or managerial capacity, or what we call specialized knowledge. Okay. What is the recipe of the Kentucky chicken? Maybe the guy who has that specialized knowledge could be transferred to Canada to work for Kentucky Fried Chicken, I guess. Okay, that's one example. Okay, it could be some other. It could be some other stuff. Okay, do we have to know the main changes to the agreement? There's no change. Okay, what I have read, there is no change. They just copy and paste section 16 of NAFTA to CUSMA. Okay, so that makes it easier for me because I don't have to update the presentation too much, and easier for you as well. Okay. Do the way they handle dispute and so on? No, this is about trade. It's not about immigration. Okay, so essentially for us as immigration consultants, we have to know who can come to Canada to get a work permit. Okay, so this is where it is limited, our field of knowledge. Okay, but now how about lumber? How about milk? How about pork? And how many kilos or pounds of pork is being traded? I have no idea. We don't have to know so far. Okay, so the intra-company transfer, this I was to say, it has to be what we call a qualifying relationship. Okay, but again, this is a matter of interpretation. What is a qualifying relationship? EPE, the entry exam, should not ask you about interpreting. Okay, is this serious criminality? Is this medical excessive demand? Is this misrepresentation? There should be no question about you providing an advice about an interpretation. Okay, it's about knowledge and options for a client. Okay, so continuous employment in the previous, it's at least 1 year experience that is required during the previous 3-year period. Okay, so this is one requirement. So this is about transferring people. And then we have, I'm skipping this, okay, but we mentioned about what kind of people may be transferred. Executives, senior manager, specialized knowledge worker. I think we have an idea of what this could mean, right? Then also you could have startup visa. So again, that means there is no existing company yet in Canada, but immigration, of course, will facilitate the arrival of this team of people who want to start up, to start up. It's a startup visa in a way for a startup company. Okay. Here we may have a look a little bit, if you wish, okay, at must the company be headquartered in North America, or could be branches? It could be branches, okay, as long as you have, it is, they're related between them. Example, HSBC. You could be working for HSBC in New York and be transferred to HSBC in Montreal. Now, where is the headquarters of HSBC? Where is the headquarters? Is it in Hong Kong or is it in London? London, okay, they better stay there. Okay, yes, okay. Can their dependent family member comes with them? In certain instances, yes, as any, not to forget, they're all Americans or Mexican. So their visa, there's a visa waiver for them. So they can all come as visitors for the time being, and eventually they can, minor student can study without study permit. And how about the open work permit? Well, this is not necessarily agreed. So the NAFTA does not guarantee the issuance of work permit for these individuals, but I would think significant benefit. It does say that someone who is working in a NOx 0AB for more than 6 months, the spouse would be entitled to an open work permit. So I would be inclined to say yes. Okay. So for Kusma, is it good enough to read these slides, or do you suggest to read the whole agreement? There is one page, okay, it's only one page that you may want to read. And I have it here, not Zoom, sorry, not this one. Okay, this one here. Okay, it's a long page though. Okay, it's a long page, but it's all there. Okay, so you don't have to read everything, but answers to question at the entry to practice exam about Kusma is there. Okay, you have a definition of what is a visitor. You have all the definition here. Okay, so who may enter Canada, who may not, what is exactly an investor, what is a trader, what is, and so on. Okay, what is sales, what is after sales. It's all there on one page. Okay. Okay, so let me give you this link here that I will copy for you in the chat. Okay, so then you don't have to search for it. Okay, that is for Kusma. Okay, which is, as I said, identical. I have actually, it's a little bit more detailed, this page, than what I used to have with the NAFTA agreement. I've went through it a couple of days ago, and I looked at it. It's almost identical. Okay. Can you give an example of how the question would be worded on the EPE? Oh, well, maybe you have an Iranian national working for Microsoft in the United States as a senior analyst who gets a job offer by Microsoft in Vancouver. And he's asking you if he heard that CUSMA would allow him to apply at port of entry. What do you think? Yes, no problem. No, he's an Iranian. He's certainly restricted and sanctioned and so on. I don't know. You would have answers of this sort. The answer being what? Being an Iranian national working in the United States, the answer would be no, because you need to know that it has to be an American citizen. Okay, maybe I don't know. I'm just trying to. You're asking me to improvise, so this is my improvisation for this NAFTA, this CUSMA question, or Mexican, of course, or Mexican. Yes. Okay, so this page, I think this page is quite useful and not useless, far from useless. So if you have time to review it, yes, it is. Okay, it is. There's another page that you need to look at. I don't know if I have mentioned it, but it's a safe third country agreement. It's not very long to read, but you have all the exceptions there. Okay, here. You have here where the agreement, the exceptions to the agreement, and you have a detailed description of what is a family members, what are the exceptions. So this, it doesn't take very long to read. And once you're familiar with it, I give you the link here, you're able to answer one or two questions. Now, every question counts, of course. You may think only one or two, that's good. Okay, that may make the difference between having to retake and not having to retake. Okay, okay. For this, let's see what I have else. What else I have for you? So
Sorry,
here,
can I ask you a question on third safe country rule?
Sure.
For the exception, family member, if the family member is in Canada who is in pending status, who
Yes.
also claim the refugee. So does it qualify the applicant to fall under this exception?
Yes, you see on the screen here, you see has made a claim for refugee status that has been accepted, and has also, just a second, has made a claim, has his removal order is here, is over 18 and has a claim for refugee protection that has been referred to the RRB for determination. Okay, so it is an exception.
I see. Thank you so much.
You're welcome. Okay, so yes, those family member exceptions you need to know. Again, also the unaccompanied minor exceptions you need to know. Once you know this, you're able to answer one or maybe two questions at the entry to practice exam. Okay. Okay, so we'll be covering IAD, RAD before Monday. Or I can cover this now. Those are very simple. Okay, IAD, RAD. What is RAD? Refugee Appeal Division. You need to know two elements, okay, for a refugee. Let's move on. I don't want to, I don't want, I think it's not necessary to spend time on CETA. Okay, it's a little bit time consuming. It is very likely there will be no question. Of course, you can always by yourself, if you want to play safe, make a research on the web and see what is the CETA exactly. Okay. Okay. RAD, what you need to know about the Refugee Appeal Division, okay, is that a refugee claimant who's been denied status at the Refugee Protection Division may appeal to the Refugee Appeal Division that decision. What is to know? Deadline is 15 days, 15 days, okay? That is 15 days. That is very important for you to know how many days. Second, let me get the screenshot for you here. I'll be right back. This is refugee won't be long. Refugee, because you have an interesting screenshot for you that I where are those refugees here? We did cover refugee together, but just a reminder, this is the screenshot you need to look, you need to have. That is where are you? Okay, share screen. Okay, sharing. Back to my PPT. This one here. Okay, what you need to know with the Refugee Appeal Division is who does not have a right of appeal. Okay, and here you have the listing of people who cannot make a refugee claim at the Refugee Appeal Division. Okay, so that's all you need to know. Who may make an appeal, 15 days to appeal, and those who are excluded. Okay, those who are excluded, DFN, claimants who withdrew, manifestly unfounded, no credible, exceptions to Safe Third Country Agreement, cessation, vacation of refugee protection. Once you know this, if you have a scenario, Roberto from Colombia was denied refugee status, he wants to know if he can appeal, and he was denied status 13 days ago. Okay, so yes, it's within 15 days. No, if there was no credible basis or whatever it may be. Okay, so then I cannot imagine too many questions apart from this. I doubt you will have questions that you see with some other mock exam about the translators. You want to change the language, you think it's not fair, and so on. I don't think you will have those questions about interpreters and so on. Here, is there any case in HNC where removal order can stay? That is a decision by CBSA to stay or not to stay. Okay, so then they may get a phone call from RCIC or from the lawyer, or it's a matter of intervention, and then CBSA may say, okay, we'll stay the removal order. Unless a lawyer would go to federal court and request the judge to order a stay. That is possible also. Okay, just a second. Is there any case because in Safe Third Country Agreement it says under exception if family members as removal order and stayed on HNC ground. Oh yeah, that is the yes. Okay, that I did not read the second part, but yes, it is possible. Okay, it is possible that CBSA was okay. Let's have a stay on that removal order. Okay, you have the same yes under HNC. Okay. Will there be question about proceedings? Not really. Then there are 13 categories listed in the code, but we are missing PowerPoint document. Yes, no, that will not be possible if we cannot cover. I mentioned that Canadian immigration policy, we have seen this in the very first, that is the very first one. Okay, this is the very first topic. It is uploaded, including administration law. They may not be PPTs, but we have covered the topics. Temporary residence, and labor market impact assessment, maybe not. HNC tribunals. I am covering it now. Okay. Okay, so there's not necessarily documents, but the topics are being discussed in class. Okay. IAD, okay, let's see what time we have. Okay, IAD, let's have a look what's very important about the Immigration Appeal Division. You need to know who has a right of appeal, who's losing the right of appeal. That's about it, okay? And the deadline to appeal. Okay, so that is, you have all this in one section here. Let's review together. Okay, let's review together. Here we have the competent jurisdiction is the Immigration Appeal Division. Okay, who has a right of appeal? So first, let's review who has a right of appeal. Okay, so a sponsor. A sponsorship is being denied as a member of the family class. Okay, so you see here it's specified as a member of the family class may appeal the IAD. So we exclude here spouse in Canada class. Okay, so this is, let's clear this. So a sponsor has a right of appeal. Okay, then we have here the only foreign national who does have a right of appeal is when that foreign national holds a permanent resident visa and is being issued a removal order. Okay, most likely at port of entry. How can the foreign national with a visa who is not a permanent resident being issued a removal order? It has to be at port of entry. That foreign national does have a right of appeal. Okay, so far so good. Then we have an appeal for a removal order being issued to a permanent resident or a protected person. Not a refugee claimant, a protected person. Okay, person has a claim but is not yet a claim approved, is protected but is not yet a permanent resident. They may appeal a decision to make a removal order against them. Again, under subsection 44. Okay, so removal order may be appealed. Okay, and then we have residency obligation outside Canada. A permanent resident may appeal to the IAD against a decision made outside Canada on the residency obligation. What is this? This is the permanent resident without a PR card, applied for a PRTD. PRTD was rejected on the ground that the person did not comply with residency obligation and will lose PR status. That decision may be appealed at the IAD. And there is also, finally, the right of appeal by the Minister of Public Safety, may appeal to the Immigration Appeal Division against a decision by the Immigration Division in an admissibility hearing. Here we have a CBSA officer writing a Section 44 report. Someone is inadmissible, sending the case to the Immigration Division for an admissibility hearing, and the member decides that the person is admissible. Most likely that would be the case, and the minister considers that there is an error, okay, and will appeal that decision to the IAD. Okay. What are the deadlines? We saw Refugee Appeal Division is 15 days. IAD is 30 days. Except decision outside Canada, you have 60 days. Okay, so this is what you need to know for who has a right of appeal. Okay, but then we're now starting to remove some of these because of inadmissibility. Okay, inadmissibility, so no appeal may be made. Okay, either by a foreign national, the sponsor, a permanent resident. If we have here an inadmissibility issue that deals with security, human rights violation, serious criminality, organized criminality. Okay, so 34, 35, 36, 137, no appeal. So some individual, initially we saw have a right of appeal, but they just lost it if the inadmissible grounds is one of these. So far, so good. And then we have the exception to the exception. That is for serious criminality. We say, but if the inadmissibility for serious criminality occurred in Canada, the conviction took place in Canada, and the jail time was less than 6 months, we give the right of appeal back to the individual. Okay, isn't that nice? And then we have misrepresentation. If in regards with a decision on sponsorship, sponsorship being denied because of misrep, there is no appeal, except if it's the spouse and the kids. then again, the sponsor will have a right of appeal. Finally, we have HNC. Okay, here we have, I would be tempted to have a question like this in an EPA exam just to make your life difficult. Okay, HNC for the purpose of a sponsorship will not be considered if the individual being sponsored is in fact not member of the family class. Okay, what does that mean? You could have a sponsorship being denied because let's pretend the wife, let's pretend, okay, you sponsor a lady. The lady has been previously married, not divorced. She does not disclose it and she's married to the sponsor. Misrep, right? And the application is denied, let's say for misrep and bigamy. Okay, so the sponsor appeals and invoke HNC, but HNC cannot be considered in this case. Why? Because the lady Dobie is not a real spouse of the sponsor because she's already married to someone else. So therefore, she is not, that foreign national is not member of the family class. So therefore, HNC cannot be considered. Okay. Otherwise, appeal are allowed on what grounds? The decision is wrong in law. So we're doing administrative law here. Okay, just in case you're wondering, when we do administrative law, the decision appealed is wrong in law or fact or mixed law and fact. A principle of natural justice has not been observed, or you have the HNC ground. Okay, yes, that is the prerogative of the Immigration Appeal Division to invoke, to consider HNC ground, taking into account, guess who, the best interest of child affected. Okay. That's all there is to me, to the Immigration Appeal Division. Okay, you could read the rules, okay, about how many days and what kind of document. Oh, question also about what is the standard of proof required, balance of probabilities. Okay, that is what you would have here. Okay. Okay, so let me see here what's in the chat because I did not read the chat while I was, so refugee 15, yes, decision made outside. So if jail time is exact 6 months, then no right to appeal, correct. So right of appeal for not meeting the residency. So if the same decision is made at POA, the option will be the right for the PR on a removal order. That is correct. Okay, what about IAD rule? Should we know? You could read. I would personally, I would not print them, but maybe I would read to see what's in there, just as a refresher. The solution would be to apply as a conjugal partner if conditions apply. Maybe this is something else. HNC can only be appealed by family member after sponsor is denied. No, it does say that all cases HNC ground may be considered. Okay, a permanent residency requirement not met. Maybe the IAD will consider HNC ground, for instance. Okay, how's that? Okay, not too bad for the trade agreements. So we have covered trade agreements. Okay, we have covered RAD, and we have covered Immigration Appeal Division. Okay, not too bad. Immigration Appeal Division, LMIA. You wish to have a look at LMIA? Sure. After the break. Okay. After the break, we'll have a look at LMIA. Okay.
Jerry, you're on mute.
I am no more mute. Okay, thank you for telling me. Okay, so I was saying, can someone clear this PR? Can clear this PR is outside Canada, PR card is expired, and PRTD is rejected. Can appeal to ID in 60 days? Yes, that is 60 days because decision is taken outside Canada. And if PR card is valid and POA does not meet, then appeal in 30 days. That is correct. Okay. And could you please allow topic to present various topics? Okay, if we see, we will review them. Okay. Okay, so we're all set. So let's have a look at LMI, Labor Market Impact Assessment. What question will you be having to start with? Always, questions are always about advertising. Okay, what are the requirements? What are the minimum advertising requirements? So usually it's about this. Could be a question about high wage, low wage. If it's a high wage position, you need a transition plan. If it's a low wage position, what are the employer's obligations? Okay, for a low wage position, provide airfare back and forth. Otherwise, it could be negotiated if, but do provide housing, adequate housing. The employer may or may not charge for the housing, okay, or accommodation. That would be the same with a caregiver also, which is a low wage position. Should there be agreement that the caregiver would stay in the household of the employer, what would be the obligation of the employers? And this is either optional or negotiable, charging for the housing or charging also for food, okay, that sort of things. Okay, so question about employers' obligations. So essentially, those are optionals, apart from the airfare that should be paid. Okay, also monetary penalties and other type of penalties. Okay, so this is, yes, there's been questions about this the last few exams about what could be some of the sanctions for employers who do not comply. Okay, and also the easy one, I guess that would be an easy one. How many years should documentation be archived before being deleted, being destroyed? 6 years. Yes. Okay, so that is the easy one, I think. Okay, so let's review briefly. Okay, let's review briefly. What do we see here in terms of labor market impact assessment? Let's get the pointer and let's see how it looks. Okay, we'll have an introduction. What is the LMIA? There's dual LMIA also, but questions, if there are questions, there will be mostly about temporary residency. Okay, those will be not about the dual, and I have not seen question about dual LMIA. Okay, process, the validity, job advertising, as I say, those are questions at the entry to practice exam. Consideration, how is an LMIA assessed? There are 7 factors, all in section 203 of the regulation. Just before issuing 204 are the work permit for trade agreements, if we remember. 205, significant benefit. 206, are we talking of people in need of, in dire straits, and 207 and so on. Okay, penalties. So penalties, those are the system of administrative monetary penalties. So this is important for you to review also, or to have with you, because it's a little bit technical, but there could be question about this. What would be some, you will not be facing with a specific situation, but just what type of sanctions could be facing an employer. Okay. Also, I am not talking about, but the Canadian Immigration Refugee Law Practice, the Big Blue Law Book. Okay. The Big Blue Law Book, make sure you have, well, of course, the version is updated. There's new, it's updated from time to time. So depending which edition you may have some
Gary,
information that, yes, go ahead.
sorry. What I was saying is the EAD and RID rules are there as well.
Okay.
The
Yes.
Canadian Act, Canadian regulations, all of this is in the blue book, so you don't have to print out. I was just answering
Oh, I
Mandy.
see. Yes. Okay. Yeah. If you
Yeah.
do have the blue book, then you already have these already. Question being for you to clearly label various sections. If you need to dig in your book to find a specific answer, but it's true that it's all binded together, which is useful indeed.
Yeah.
Yeah.
That's all. Thank you.
What is the blue book? What is the blue book? Do I have a copy of it's a Lorne Wallman book about immigration, and the cover is blue. It's about it's a heavy book that is kind of depressing when you're in IMCD 1 because it seems overwhelming. And then when you start reaching IMCD 10, you tend to appreciate it a little bit more than at the beginning of the class. Okay. Okay, so I usually tell students, well, I used to teach IMCD1, I don't, now I'm at the end of the line, you know, but I used to tell students, don't start with this one right away, otherwise you will regret having taken this class, okay? Is it exactly the same? It is very, very similar to the Orange book, it's just a different author. Okay, so one is, I think is it Bellissimo or no, it's not Bellissimo. I don't remember the orange one but they're very, very similar. So if you have the orange one, you don't have to have the blue book. Okay, you could also have the green book, but the green book, of course, is not as detailed. You don't have as much information in it. Okay, so labor market impact assessment, what do we have? It is an employer. An employer needs, in certain cases, to have, before being able to hire a foreign employee, a foreign national, will need the authorization to do so by having the job offered being assessed by ESDC, by Service Canada, and the assessment will determine, this is what we call, what will be the impact of the individual, the foreign national, to come to Canada and perform the position being offered. Okay, this is why in 4 words, it's called labor market impact assessment. Okay, what is the difference between ESDC? It's the same. Okay, it's the same. It's employment and social development. I think what is, yes, this is it's faster to say Service Canada. Okay, but it's the same. Do we need to know the difference between neutral and positive? I don't think you will be asked question about making an assessment for an LMIA, but just when an LMIA is required. Okay, okay, but a neutral or positive is essentially the same. Okay, it means it has no negative impact. Okay, do you need to know about the selection factors? You could. There could be one about a job. If you look at section 203, you do have the 7 factors. Okay, so yes, it would be good that you have this specific section. One, for instance, is about LMIA will not be approved if there is how do they call a union dispute or a labor dispute, for instance. Okay, so if there is a labor dispute, the LMIA will not be approved. I have seen a question of this sort in the past. Okay, so then of course you need to know that indeed, if it is not, you don't bring foreign national to solve to solve the issue that you can't hire your locals, they're on strike. So you're bringing foreign nationals instead. Okay, so that is, as I said, 203. You do have those 7 elements. I think I have these in the in this presentation. So today we will focus mostly on high wage and my idea. Okay, high wage and low wage streams. Okay, first of all, what is high wage, low wage? How is this determined? So in each province, Statistics Canada has made a determination about a median wage offered. And then you have on the RCC website a section that says the medium wages being paid in Quebec, in Prince Edward Island, in BC, and so on, may not exactly be the same. And therefore, let's say a round figure, it's $25 an hour. Okay, so a high wage position would be when the employer is offering a salary of $25 an hour and above. And a low wage position would be less than $25 an hour, according to the province, of course. Okay, so you have a chart, you have those data available on the RCC website. Okay, and the process is slightly different. Okay, for a high wage, advertising is longer, is national, because if you're to offer a high wage, it is mandatory that the advertisement may also be national, in the sense that someone from PEI meeting requirements of this job offer in Calgary may be ready to move. Okay, because it is a high wage position. So that is one requirement that is not required with the low wage position, for instance. Okay, not very big difference. The length of the advertisement, it's a minimum of 28 days, but for a high wage position, you have to maintain the advertisement until the job, the Lmia has been assessed. Okay, until decision. Okay. Also, and there is, for the high wage position, a transition plan. So how would you define a transition plan? The employer will take appropriate measures so that in the future there will be no need to rely on foreign workers. Okay, so training, that could include making arrangements so that the current temporary worker will be able to become a permanent resident. So then you would not rely on foreign workers anymore. Okay. As for low wage, essentially I mentioned already about employers' requirement to pay for the airfare and to provide, to find appropriate housing. Okay, but the employer does not have to pay for this. Okay, it may be part of the deal. That's part of the contract. Okay, and there is a standard contract. Okay. Before the end of this class, can you briefly talk about what we should know about Quebec? Yes, give me ring a bell before 15 minutes before the end of this class, so that I can speak to you about Quebec. Okay. Question: the safeguard, the CBSA doesn't apply to stateless person. Site says it doesn't apply. Yes, it is an exception. So the Safe Third Country Agreement does not apply to stateless. So a stateless person comes to port of entry, that person will not be returned to the United States. Okay, this is what it means. Okay, so for our low wage stream, they will have to provide housing and transportation. Correct. Okay, so you said the advertisement for low wage is 28 days. Yes. Okay, so let's have a look. Okay, let's see what we have on this good looking PPT. It seems. Okay, so the idea is for employer that who would have difficulty finding staff in Canada, temporary, no, I mean permanent resident or Canadian, then could rely on a foreign national. two possibilities for the labor market impact assessment. It can be for temporary purpose, that is with a work permit, but at the same time, sometimes we call this the dual LMIA, the dual LMIA. It's equivalent to arrange employment. Okay, that would be essentially for a foreign national outside Canada who would benefit under express entry of extra points, 50 or 200 according to the occupation. And dual LMIA has no fee. Exactly. How come it has no fee? That was an incentive by Immigration Canada for employers to have a look, give access to the pool. If someone are already in the express entry system, how about helping them to come to Canada as permanent resident and offering these people in the pool a job offer, a job, okay, with LMIA. Therefore, the fee would be waived. The $1,000 fee would be waived. Okay. Okay, so dual, so it has two purposes, permanent residency and also temporary residency. Okay, so we have here, what do we have? The temporary foreign worker program. So the employer needs to pay the fee, as we saw. If it is for permanent residency, there is no fee. A little bit less supporting document, but I don't believe that that there is so much difference between the documentation. But for permanent residency, someone in the express entry pool with an LMIA approved would get bonus point. We remember this, either 50 or 200 for three types of program: federal skilled worker, federal skilled trade, Canadian experience class. Okay. For the temporary foreign worker program, if we move to the left-hand side, it is essentially for two type of program: high wage, low wage position. Okay.
Jerry,
Yes.
can I have a question?
Sure.
Do you know if when a person has a job offer based on LMIA, practically he or she would get 65 points, right? 50 because of job offer, 10 because of the employment, arranged employment, and 5 because of adaptability. Is it right? Can you say it like that?
No, cannot. Okay, I know how you understand it. You need to split. There's two different programs here that you include. One is the express entry system.
Yes.
So then the
I'm talking
person
about that
would
one.
get, yes, the person would get 50 points in the express entry system.
Right.
And for the purpose of federal skilled worker, the
Right.
grid of federal skilled worker, then indeed the person would get 10 extra points for arranged employment and
Right.
five extra points for adaptability.
Okay. But in other categories like ECE and federal skilled trade, we don't have these 15 extra points.
No, because there's no grid system. Either you meet but federal skilled trade, you must, no, you don't need to have a job offer, but that would be a requirement to have a job offer. Then you would meet one essential requirement.
Right.
Canadian
So this
experience class, you
understanding
would, sorry, go ahead.
This understanding is okay, right? Just about the skilled worker, federal skilled worker, not about two other categories.
Yes.
Okay, thank you.
You're welcome. Okay. Federal skilled job offer must be LMIA approved if the individual is abroad, if the individual is already in Canada with a work permit, then that could be arranged employment only. It may not have to go through LMIA process. Okay. Okay, so those two programs, one is to hire a temporary foreign worker, and the dual, the LMIA for permanent residency, of course, it's to facilitate permanent residence visa. Okay, so this is why we call this a dual LMIA, which is equal to dual intent, actually. Purpose being hiring someone on a temporary basis, but at the same time facilitating the individual to become permanent resident. It has to be, not to forget, we're dealing with NOC 0AB here, because it goes through express entry. So it has to be most likely, not necessarily a high wage position, but it has to be a NOC 0AB. Okay, so the procedure, so let's have a look at this. Okay, so first thing is to determine the eligibility of the LMIA. Is the employer meeting requirements of being a Canadian employer? Then you have the advertisement that must be for at least 28 days, or let's say 1 month. And the advertisement specifically for high wage position must keep going until the decision for the LMI. Okay. Then you have the application, and it will be processed, of course, by ESDC. If the decision is negative, then it's done. That's the end of it, except if the employer will go for judicial review. But if the LMIA is a positive one, question, the validity of the LMIA is for 6 months. Okay, not the job, but the LMIA itself, which means that the foreign national has 6 months to apply for the work permit. Okay, there has to be a contract with the foreign worker. Very often it comes at the beginning, it comes with the application package as well. Okay, and the foreign worker will be informed that the LMIA was approved and is now able to apply for the work permit. Okay, so
Jerry, a short question.
Sure.
Who's going to determine it is low wage stream or high wage stream? Is that the employer early on, or later ESDC does that?
Yeah, the employer.
Okay.
By stating how much he's willing to pay the welder or the computer analyst or whoever.
And then depending on that, he will have to prove that he has made necessary transportation and accommodation arrangements to ESDC in the first application itself.
If it is a low wage position, yes.
Okay. Okay.
Yep, sure. And so if they go for it, they will have 15 days from decision. Yes. Because it is an immigration decision. It's under the Immigration Act, so it's 15 days. Okay, so here, once the foreign worker has copy of the LMIA, the documents will do the biometric most likely, and then will need to come to Canada. And then here, of course, let's forget about the various procedures during COVID-19, but if the individual needs or does not need a TRV. If the individual only need an ETA, the person then may fly to Canada and get the work permit at port of entry on the approval. Okay. Otherwise, TRV will be approved as well, or the ETA, and the person comes to Canada and the work permit is issued at port of entry. Okay, issued at port of entry. Person will need to apply for the social insurance number and then start working. It is a closed work permit, and eventually gathering Canadian experience as well. If it is a NOC 0AB, the person may upload a profile under express entry, may stay in Canada as a temporary worker, or may also consider, according to the experience and where the person is working and so on, consider a PNP program to become permanent resident. Okay, so this is what we have. Okay, this is, no, this is out.
Jerry?
Yes.
Yeah, can you go back to the last slide, please?
Sure. Here.
Yeah, so on the right side, we have 3 options for LMIA, express entry, temporary worker, and the provincial nomination. If an applicant applied for LMIA for temporary worker only, and let's say it's he is suitable for a PNP, but not applying through a PNP. So that must, that would definitely need LMIA.
Not necessarily. What we see here, those three, it's not exactly linked. The person is in Canada on a work permit, which is a federal issued work permit. But should the person be working in a specific province, may meet requirements of that province to apply under a stream of that PNP program. Being already in Canada, gathering Canadian experience in that specific program, so may apply under a PNP. Many PNP program requires that an individual has worked or has stayed in the province. So therefore, that temporary worker being in Manitoba, for instance, maybe would be admissible to one of the Manitoba program being offered to receive a certificate of nomination. This is what it means here.
Okay, but if no PNP program the applicant is going through, then the applicant
Well,
must need it.
the program, the individual is a temporary worker in Canada. And should that temporary worker in Canada wish to become permanent resident, will have to consider express entry if the individual has a profile that would fit one either Canadian experience class federal skilled trade or federal skilled worker, and upload the profile and eventually become permanent resident if requirements are met.
But in case of foreign applicant, in case of foreign applicant and applying for only temporary worker, not any PNP, just to work. So that means they must need LMIA.
If the person is coming from abroad, yes. Yes.
Okay, that was my
absolutely.
question. Thank you.
Yes, okay, yes. Okay, so after, just a second, I read a question here. After LMIA approval for foreign national not eligible for ETA at time of approval, shouldn't he apply for work permit? Well, the foreign national who is not eligible for ETA, the electronic travel authorization, first will make an application for a work permit. But if the person has a passport that is not ETA available, a TRV will be issued to that individual, so that individual may fly to Canada and get the work permit at port of entry. Let's say you come from the Philippines, you apply for your work permit, then they will issue a TRV in the passport to allow the worker to reach Canada and get the work permit. You see, it's okay now? Understood? Okay, that's the most important.
Yes, sorry, Jerry, but at the time of receiving an LMIA approval, we will submit a work permit application. Then the embassy will issue the TRV approval and passport request or passport request.
Correct.
Understood.
Yes.
Thank you.
Yes, exactly. Unless the individual has a passport that does not require a TRV, then an ETA will be issued to the individual.
Understood. Thank you.
Okay. Unless, okay, there's an unless the foreign worker is an American, but then would not need TRV or ETA. Just direct to Canada with the letter saying the work permit was approved. Okay. Okay.
Yeah, I have a question for you for you as a practitioner, let's say, or someone who has been working in this field for a long time. My impression about this LMIA business is that it is very, very, very rare cases that we may be facing, because if you think about the employers who are in Canada right now, looking for people who could not find the same qualification here, you'd find that it is not a very, very common and very familiar and very popular option, because in most of the cases we have a percentage of unemployment, and whenever you are requesting an engineer, there are hundreds of engineers. If you are requesting, for example, whatever, you will need a cook, you will have hundreds of cooks for all nationalities. So Do you have this impression that this LMA business is for very rare cases? Or
No, no, it depends. If you're looking for a welder, there's no welder in Canada. So definitely, or nurses. Okay, they're different type of nurses, and so there's different type, or food processing. You go to the Maritimes and they have plants to process food, and there's nobody available to do the job. So then you bring in foreign workers from the Philippines, from Burkina Faso, from many countries, and they come on
bring
work
them
permit.
in the temporary workers coming for, let's say, like the one who are coming only to harvest some apple or whatever.
Yes, yes, yes.
It's easier
Fruit
for you
picker,
than
yeah.
coming into all this process of LMA process, right?
Pardon me?
Is it would it be easier for you than this LMA process, and let's say a little bit cheaper to go with that temporary workers program?
Yeah, but they come under the LMIA, those seasonal worker. But they come as a group very often. They have agreements either with Mexico or the Caribbean islands, and the employer needs, let's say, 50, 60, 100 temporary workers for 5, 6, 7, 8 months, then go through an LMIA process for all these individuals. And these individuals comes to Canada, they're being provided housing, and they work for a certain amount of time. Those are NOx C and D, they're not NOx 0 AB, so they return to their country after the job is done.
So, but this is a kind of a high cost, let's say. If you have 50 employees, you have 50,000 in fees only, not to mention the work.
Yes. But otherwise, what do you do with the crop? There's nobody to do the job here now to do this job.
Okay.
I remember, for instance, I'm familiar with BC in the 70s. I'm old enough to remember the 70s. All people working in the fields in the Okanagan Valley, they were all hippies. Okay, working summertime, leaving the place, but they were all Canadians. But then the story has changed, and then now they're all coming from Mexico to do these jobs. Right. Okay. So let's try to. So that's the definitely no question about the purpose specifically. Apart from saying that the purpose of the LMIA is to make an assessment, that is a labor market impact assessment on the labor market, and is the employer able to demonstrate that there is nobody to do the job, that specific type of job in Canada, and the employer has demonstrated through advertisement, essentially, that indeed the person was not able. Not to forget, ESDC, when they approve, they don't have a list of occupation as such, but they know what type of occupation that obviously the employer cannot find locally. Okay. And
sorry, Jerry, can I come back to the previous question I asked where you said there will be another exception or unless you mentioned the second time when you mentioned unless that there is that there will be a citizen, a nationality that requires an ETA, that would also apply to NAFTA as well. So for example, that will also apply to the NAFTA individual as well. So in the NAFTA agreement, if it's a U.S. citizen, then there is no LMIA required. So that means that he can what would happen in that case? For example, the employer in Canada applies, puts a job advertisement, and somebody from the U.S. applies to that job, and the employer says, okay, I want this U.S. citizen I want to hire this U.S. citizen. So does the Canadian employer need to apply for LMIA?
No.
During that time?
If it meets the NAFTA agreement, it would have to be a professionals. It cannot be a welder, for instance.
Okay. So it has to be executives, managers, and specialized knowledge individuals, you mean, the three categories?
No, just the list of 63. There's a list of professionals. There are 63
Okay.
occupations. So therefore, the employer would say, I need a computer analyst, and this guy working for Apple in the USA would suit me very well and is an American citizen. So then they could make a job offer without LMI in that situation.
Understood.
Good.
Thank
Okay.
you.
Okay. Well, of course, when we mention NAFTA, it's CUSMA, but it's the same. Okay, essentially, the agreement is the same, so you could have questions of this sort. Just to make sure there's no misunderstanding that it's true that specifically NAFTA is gone, the procedures are still there, okay, for an individual. Okay. Okay, so what did I say? So let's try to see what we have more on this. Oh, here, this is about processing time, so it's not current anymore. I have checked the processing time. It's amazingly fast these days. A low-wage job is being processed in 34 working days now. It used to be 110 days. Okay, so I don't know what's happening here. It seems that her remote work is efficient, or many employer has decided not to hire also. So they have probably closed a number of LMIA application, I cannot say. Okay, so what's to remember, of course, the LMIA is valid for 6 months. Okay, so a maximum period of 6 months after it is issued, which means that the work permit must be, the worker must apply for the work permit within 6 months. Okay, during COVID is 9 months. Okay, and this we have, of course, this we won't go through the details of how to submit an LMIA, about what kind of contact, what kind of information. You have application forms for the LMI, high wage, low wage, quite similar, about 15, 17 pages of a PDF form, where obviously you need to provide a substantial amount of information from the employer. Okay, how many employees, what are the salaries, and how many are already foreign workers, because there's a cap on number of foreign workers. So there's a substantial amount of information. Advertising, however, at least 4 weeks, it has to be demonstrated. It can be, one is mandatory, so question about the advertising. One is mandatory is job bank. Okay, if it is a high wage, and then you will be offered maybe at the question, if there is a question about this, which of the following possibilities are allowed as advertising. So you have union, association, website, newsletters, union community site, ethnic group site, but it exclude website that you need to be a member. Okay, Facebook, you need to be a member to have access to the information. LinkedIn, you need to be a member. So those websites do not count as proper advertising. Okay. In terms of interview, the SDC needs to see this as well. Well, it could be. You could, if depending what, everything depends on the employer also. Who is the employer? Okay. Are we talking of a serious bona fide employer who has a processing plant, he's building equipment and so on, and we know the employer and he needs a foreign worker? What kind of investigation will you provide compared to a little tailor shop, I guess, with 4 employees, and you've never heard of it? Okay, so is it to bring the cousin from a distant country to Canada through an LMI, or is it to bring a worker that is required to facilitate the economic activity of the individual? So minimum 1 advertisement is national level. The national level is required for high wage position. Okay. and job bank, which is national. Job bank is also a requirement, a mandatory requirement. Okay. So consideration on the assessment, essentially is based on those section 203, those 7 factors. Okay, so would you need to know? Maybe has said so verification of the contract, transfer of skills, a recruitment effort, job creation, wage and working condition, union consultation, no labor dispute program, no labor dispute in progress, labor shortages. So those are the main elements, of the assessment, okay, of labor market impact assessment.
Jerry, can I ask a question here?
Yes, you can ask a question.
It's so in regards to the LMIA process, you mentioned in 2 slides back where you mentioned that we don't you won't take us through the whole process of submitting an LMIA. But my question is related to the Article 11 under the ethics, where it says that 11.1, where it says the member withdrawal from representation, the member, point number 4, member is not competent to handle the matter. So for example, as a new RCIC, fingers crossed, if the LMIA, if a client comes to me being an LMIA, submitting an LMIA process, and I'm not familiar with the process, so wouldn't how wouldn't that be me being incompetent under the section 11, Article 11.1.4 under the ethics?
Could be. Depends how you feel and how you are. It's not because you have never done one, never submitted one, that makes it incompetent. It's the question of understanding, fulfilling the application, the requirement, the information. This is when you need to ask yourself if you are competent to fulfill the professional side of it. Okay, if you have the knowledge, the competence with your employer to properly identify what is the NOC code, what is the job descriptions, what are the needs of the employer, and so on. This is what we mean by being competent. It's not because you have never submitted one. All of you, officially speaking, will have to start with a first application, a TRV, a student permit, and so on. So that does not make you incompetent for this. This notion of incompetence, or it's not being incompetent, it's not being competent. It's not exactly the same meaning. It's more about, for instance, the complexity of the task. If you think it's too complex for you, it gives you a headache, then you may wish, and this is what section 11 will say, you ask your client that you will be working with someone on this one. Okay, so that is the question to answer at the entry to practice exam as well, because this is a standard question that comes at the exam.
It's not related to experience, it's related to knowledge. Competency would be related to.
It's a mixture. If you look at the Code of Ethics, it says the knowledge and the expertise or the experience. I don't remember the exact word, but it's there's 2 elements put together.
Gary, I have a question. The question is, if in the retainer agreement we may, let's say, seek the advice of other consultant as well. If we put this one, do we need to ask again if that kind of, let's say, competency happens from the client again? That's we may seek another, let's say, advisor or
actually the new, it's relatively new, the new retainer agreement regulation says that if you are to work with someone else, seek consultation, cooperation, participation, whatever, the name of that other consultant has to be mentioned in the retainer agreement and describe what will be describe what will be the duties of that other consultant. Then obviously, if all this is mentioned in the retainer agreement and the client sign, that means he or she agrees. Okay, you're okay with this? Yes, I guess so.
yes, yes, thank you. So
I
we
just
cannot
want
use
to
the
clarify on
general
the
term.
competence. So you say competent is basically as long as you think you are competent to do the assignment, then you take it. It's not. This has nothing to do with that you never done that assignment before, right?
Yes.
Okay. Yeah, that's it. That's all I want to confirm. Thank you.
Okay, but it can also be, for instance, if some of you you meet someone who wishes to go to Quebec. Through a Quebec, you could be you could have the knowledge, the expertise, but not be competent because you're not registered with Quebec. So that would make you not competent to do a Quebec case. You see, so this is what we mean also by being competent. You would tell your client, I'm not competent to do Quebec cases. You could use other words, but you say, but I will be working with someone who is, okay, who is registered with Quebec. And then on the agreement, retainer agreement, you would put down who you would be working with. Okay, so let's try to come back to LMIA now that we've covered some of the RCCIC Code of Ethics and competence. Though it's true, you will have question about competence. You will have scenario. Okay, so here we have, I was to say, yeah, this is where it is. Conditions and requirement. Of course, the employer has to meet a number of conditions in terms of ensuring that the contract will be respected, the contract will be fulfilled accordingly to what's written. They could be investigation, enforcement, or audit, okay, by either ESDC or CBSA. All records must be kept for 6 years. That's the easy answer. Again, you must inform ESDC of any changes in contracts and so on. So that is standard issue. Okay. Employer must remain actively engaged in the business, must comply, they must comply with all federal, provincial, territorial law. Okay, employer must provide each foreign worker in the same occupation as stated in the offer of employment. What we see here, the offer of employment, this is how it's been approved with a contract that is part of the LMIA. And therefore conditions have to be either equal or better. Okay, but it cannot be less, okay, in terms of activities and so on. Which means making sure the employee will not complain. If there's a promotion or if the activities are upgraded, including salaries, of course, there's no issue here. It's just that when the job description is being downgraded, that does not fit the requirement. Okay, so that is specific agreed to commitment. Okay, so employer must meet the LMIA was issued directly to the job creation. And we're talking here of 203 and the condition transfer of skill, knowledge for the benefit of Canadians and so on. The cap works with low wage stream. Yeah, there is a cap. The cap being 10% of the total workforce. So when you fill the application, when you complete the application for a low wage application, then you need to describe how many employees, you need to state how many employees are in the plant. or in the boutique or whatever, and then how many of these would be already foreign workers. And then there's a complex method, but not that complex, but there is a method to calculate with some percentage. And if you are below the 10%, then you can proceed with the application. If you're above the 10%, then you can't hire a foreign worker in that position. Okay. Is 10% for high wage as well? Would have to look at the application. I believe not for the high wage position. Okay, not for the high wage position, if I remember, because I remember someone I was working with told me that they were hiring nurses and there was no cap for high wage. There is no cap. Okay, yes, Mercedes tells me this, and I would believe so, because now I remember specifically for nurses in Quebec, some clinics, some places, and they do hire nurses from a foreign country, and there's no cap. Okay. Actually, the Premier is begging people to become nurses, so I don't see why there should be a cap. Okay, so a reasonable effort to provide the workplace, and those are the compliance aspect. Okay, the compliance aspect. Employer must be able to demonstrate that any information was accurate. Documentation must be in file for 6 years. Employer must report at any specified time and place to answer questions and provide documents. Okay, so yes, there is a possibility of inspection, of audit. Okay, employer therefore must attend any audit, any inspection. What else? As for a private, medium wage, when medium wage are used for both high wage and low wage, the medium is the mark. Okay, it's like how would I say? I have an image in mind, but it's not exactly the better one for you to understand. But if it's medium wage and above, it is a high wage position. Okay. Question, what happens if you're employed by a company and the previous RCIC before you did not have a prompt calendar file manager? Do their application, their filing system now file for the new? No, it does not. Or the new RCIC only responsible for the application they complete. Only the new, you can't take responsibility from previous RCIC. And this happens fairly often, that you will have a client, well, it depends who, but sometimes you have clients who say, I'm leaving my former RCIC because I can't get documents, he's not following up, he's cheating, he's incompetent, and so on. Would you want to take my case? You say, sure. And then I will say, give me what you have. And sometimes they don't have much. They may not even have a copy of application for extension and so on. So I cannot take responsibility for the previous authorization, obviously. Okay, that would not be fair. Okay, in Lmia, there is a section on substantial assessment. What that section is referring to, year 30, this I cannot say what this is about. Okay. Substantial assessment. Is there a limit on low wage position per location? It's per, yes, it is per location. Okay, so if you have an employer with 2, 3 different plants, for instance, it's per specific plant, plant number 1, plant number 2, plant number 3, unless in the Lmia that the employee will be working in different plants. Okay, so then you have to calculate differently.
Okay. Can you please quickly go to the reasonable effort slide? I'll take a screenshot quickly.
This one?
Reasonable effort, just previous. Yeah, that's
This
it.
one.
Thank you.
Okay. Okay. You're okay now?
Yeah.
Okay. 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 So for instance, no, now I will forget the case law. Okay. But it is essential, of course, that that the rate of pay be according to, it's written here, the LMO, the labor market opinion. That's a former name for the labor market impact assessment. Penalties, okay, penalties. This is what's important. If employer who would be found non-compliant could be subjected to a number of penalties. So those are on the screen, the one you need to know. Okay, a negative LMI would be issued for any pending application. A ban for 2 years possible for using the temporary foreign worker program or the EMP. Publication of names on the website. And maybe revocation, suspension of previously issued LMIA as well. Okay, so those are some of the penalties that you need to know. Okay, and it could include a warning. Monetary penalties, question last time, $500 to $100,000 per violation to a maximum of 1 million. A ban of 1, 2, 5, 10 years possible. Publication again on names on website, and revocation and suspension. That is for that is after December. Yeah, this is the new one. Okay, what we saw was, just a second. Let me see, where is it? I want to move it back. Prior to December. Yes, okay. So this is what you need to know. Okay, so delete your previous screenshot. Okay, this is what's important. Okay, what happens when the medium wage changes while LMIA is processing? Then the employer has to adjust. Will have to adjust the amount offered. Okay. Okay, what else? So this is, and we saw about the monetary penalties. Okay, this is another case law that I will skip. So this is, I will skip this, and let me see. Also, but of course, you will not be asked to go through the very detailed way of calculate the penalties, the sanction, because there's a sort of chart according to the type of violation, the frequency of violation, the size of the employer, and then the monetary penalties would fit with a complex calculation system. You don't need to know this, okay? So that would be very unfair from the RCCIC to ask you a question about this. You know, this is would be too much, okay? So let me know if that is the case. We'll go public with this, okay? Also, when imposing the penalties, of course, those are the equivalent of an administrative tribunal. So did the violation results from a genuine misinterpretation? Did the violation results from changes to the law? Were error made in good faith, and so on? Okay, so all this, I suppose, on balance of probabilities. Okay. So when you apply for LMIA for 20 people and pay $20,000 LMIA fee per temporary, and then LMIA is refused. Yes, indeed. So certainly, certainly. Okay, conclusion. Okay, conclusion. So here, well, most LMIA in Canada, in terms of number, many are issued for the agricultural sector. Okay, but I'll leave the stats here. This is actually, this is not a PPT for the entry to practice exam, but it gives you some information on the essential information about the LMIA and how to answer most likely questions at the entry to practice exam. Okay. Is the LMIA a good option? Certainly a very difficult program for the Canadian government to manage the last, I would say, the last 20 years. Initially, a temporary foreign worker program was for only very, very few people that Canada could not find locally as permanent residents. But then the program has become It's called a temporary program, but it's become a permanent program for many individuals. As a young person, I would not imagine that one day foreigners from Mexico would come and pick fruits in our field so that they would be put on the market later on. This is unbelievable, but this has been the situation for many years already. Okay, so
Jerry,
that's the end.
question to
Yes,
confirm
question,
about
go
the
ahead.
LMA fees. You mentioned LMA $1,000. Is that per person or per application? What I'm trying to ask is, say like a farm, they want to sponsor 20 people from Mexico. So is that
Yes.
20,000?
No,
right?
that would be actually, it's per you're allowed to. I have seen a number of LMIA that would include, for the same job description, the name of many employees, and this is only one application. Okay, so you
Okay, so
pay
that
for one.
is
Yes.
per application, not per
Yes,
person.
it's per application.
So
Yes.
as long as the application is in the same NOC or same job title, then you can allow.
Yes, exactly the same job description and same condition and so on.
Thank you.
So it's
Welcome.
not per person, Jerry?
Pardon me?
So it's not per person?
No,
You would-
it's not all per person. No.
Okay.
It depends which occupation you're referring to. Okay. Okay, so that's it for the LMIA. Okay,
Hi,
the
Jerry.
LMIA. Yes.
Hi, Jerry. Thank you for putting another very nice and concise presentation regarding LMIA. Would this presentation also be on the materials section uploaded?
Yes, it should be. Yes, like
Thank
all
you.
the others.
Thank
Okay,
you.
you're welcome. Okay, so let's take a break. Okay, it's break time, and we come back with I'm not sure what. Okay, but let me know. Okay, what you want, and then we'll be uploading study permit. Okay, study permit to, oh, I have 3 study permit. Ethics, but ethics, we've not seen this previously. Did I not? We did review ethics. Usually I start with ethics so that I come back to ethics. I don't like the RCCIC regulation so much, so I usually start with this. Okay, okay. Okay, let's come back. Oh yes, and Quebec, a little bit about Quebec. Okay, after the break. Okay, back to you guys for this few minutes left together. Let's review briefly about international students. International students. Everybody needs a study permit to study in Canada, except those who don't. Okay, so that's the story of immigration issues and regulation. You have an interesting section here that I've shown you before. Let me see here that deals with temporary resident status. Who needs a study permit, how to make an application, dealing with minors, refugee protected person, and so on. Let's look briefly, okay, about the essential. First, I will clear the chat here, and I'm moving. So to start with, back to basic, there's a difference between the study permit and the visa, the study visa, sometimes that is called, which actually is a TRV. It's a temporary resident visa. It's just that the purpose of the stay being to study. It looks like a study visa, a student visa, but it is not a study permit. Okay, so here for the same individual, what do we have? We have on the left-hand side a visa, a student visa, multiple entry, valid for 3 years, and a few days later, the same individual arrived in Canada and was issued a study permit. You see the name and so on. So you see, so visa, study permit. So a person could have an expired study permit, an expired multiple entry visa because a person has been in Canada nonstop, has extended studies and still on a study permit, but the visa could be expired. It doesn't matter. The question is, the individual may renew, may apply for a new student visa or TRV from within Canada. That is possible. Or also, if the person goes back, in this case to Vietnam, to Ho Chi Minh, then a person could apply for to renew the study, the multiple entry visa from over there as well. Okay, so those are different options. You see here our student category is as, but it is it's essentially a TRV. We have here question. I have not seen question about these. However, what is this SX1 issued for only 6 months usually? This is in the case. It's interesting because this is in the case of people who are coming to Canada to study for less than 6 months. Actually, they don't need, we know that if you study less than 6 months, you don't need a student permit, okay? But the advantage of having this SX1, it's equivalent to a study permit, is inside Canada, you may apply for a new student permit if you wish to stay in Canada as a student. But if you have a visitor visa, you study for less than 6 months, you cannot get a study permit inside Canada. You have to leave country and return. Okay, so that is the difference here. Okay, so it is, if the person is not sure about extending the stay for further studies, it's better to indicate that your intended occupation in Canada is to study, even though it is less than 6 months. Okay, what kind of program? So that could be any program that is of less than 6 months. It doesn't matter. It could be, yes, hello, go ahead.
Regarding what you just said, that students who study less than 6 months in Canada don't need a study visa and the permit. Correct me if I'm wrong, isn't that the case for visa exempt countries? Anybody coming from non-visa exempt country, even wanted to study less than 6 months, they still need to get the visa, study visa.
No. Study any visitor in Canada, be American, visa exempt country or visa required country, any visitor in Canada may study without a study permit if it's less than 6 months.
So someone from a visa required country enrolls in a 4-month program.
Yes.
Will still have to apply for a study visa because they are not from an exempt country.
No, the person will have to apply for a visa to come to Canada. If the person already has, let's pretend the person already have a multiple entry visa, for instance, that person can come into Canada for a visit and then take the 4-month program, does not require the study permit.
But to be clear with their intent, if they have enrolled in a 4-month program, instead of applying for a TRV, because anything that study permit, work permit is a TRV, but they have to tell that I'm not just going for a visit, I'm going to study for 4 months.
Okay, yes, of course. So then it is likely then the visa office may issue this SX1 then.
Exactly. Thank you so much.
So in this case, the person has already declared that it is to study. And this SX1 visa actually is assimilated to a study permit at the same time. It's not only a visa, but it is once in Canada, the person with this type of visa may apply for a study permit from inside Canada.
Exactly. Thank you so much.
Okay, good. Okay, so then we have, this is a student permit, this is a specimen, so this is the new standard form for a few years, US letter size. And since 2014, this is what we all need to know anyway about the condition, must study in a designated learning institution, a DLI. The person must remain enrolled. Therefore, the person quitting studies, it is the obligation of the institution to inform RCC that the student is not enrolled anymore. Therefore, the study permit will be canceled. Okay, so a person with a 3-year validity, let's say 2 or 3 years study permit, therefore could not stay in Canada doing nothing. Okay. Also, study permit becomes invalid 90 days after the student has completed the study program. Okay, so when a letter is issued, it's a program. It has to be a program, whatever the nature, a bachelor or a technical program and so on. When the institution has issued a letter validating that the program is completed, the study permit is valid for another 90 days. Okay, 90 days. So the person can stay in Canada for 90 days, can work full-time because it is break, it is a student status, but no studies, no academic courses, and then must leave Canada before the end of the study permit validity. Unless if the person is eligible for a postgraduate work permit, then the person could apply for a postgraduate work permit. And then we know that if the application is made within that 90 days, the person would remain on implied status and could work until the postgraduate work permit is issued. Okay, so this we know. Okay. But after if they do not apply or if they are not eligible for a postgraduate work permit, then they either apply to change status. They could change status either as a visitor or worker if they have a job offer, or extend for a visitor visa extension. Okay, a visitor record. Okay, they could. Okay. So ESL student in course over 6 months can work on campus My understanding is that ESL does not allow, I think I have it here on the PPT in a moment, but ESL does not allow people to work. It's not a full-time program as such. It's not considered a full-time program. Okay, but I have the information later, I think. Working off campus, okay, it's eligible without a work permit, as long as you are a full-time student at postgraduate, post-secondary school. So it must be a college or university. So easy questions, I think, up to 20 hours per week during regular academic sessions and full-time during breaks. That is off campus. On campus, if you're a full-time student registered for a program, then you can work as much as you want. There's no limit. Okay. Co-op work permit. So those are work permit issued if an individual has to work, paid work, that is part of the study program. Therefore, a work permit would be issued. Okay, when can people apply for a study permit from within Canada without having to leave? If they are at preschool, primary, secondary school, if they're minors, also visiting or exchange at DLI, unusual question, but most likely the most common is that they have completed a course that is a condition for acceptance at a DLI. So sometimes people get admitted at college, university, and they have to complete maybe an ESL and so on. So even if they don't have a study permit, not even the SX1, they're still able to apply for a work permit because the admission was conditional to those studies. Okay. Which those extra 90 days always automatic? Yes, it's always automatic. I mean, the 90 days, so you're talking of when the study permit becomes invalid 90 days after the student has completed the study program. Okay.
Derek,
okay. Yes.
will the co-op work permit be issued at the same time as the study permit?
Yes.
Okay.
Yes. And the employer is the institution. Okay. And the individual can work whatever the job has to be. Then the person will find a place to work. It's not quite, but it's a sort of mini open work permit because the it's part of the studies and can work for any work that is directly related to the studies. It has to be approved by the institution. Okay. So if given, ESL will be followed by 2-year diploma. Yes, the initial permit for would be a 6-year or regular. The initial permit, if it's applied from outside Canada, that would be an SX1 also. That because it's not required specifically if the duration of the program is less than 6 months. Okay, so DLI, all institution, this is the provinces who will identify which institution are DLI. So private institution need to apply to get their DLI number. Okay, but all primary, secondary school are automatically designated as such. Okay, so people to get the study permit, people will need to make an application, need to get a letter of acceptance from a designated learning institution. That is the first essential requirement, getting the letter, and then the person apply for both the study permit and, if required, the TRV and the temporary resident visa, pay the fees, biometrics, medicals, and must not be inadmissible and meet eligibility requirement. Okay. What do we have here in the chat? I'm confused according you when you must say you must stop working. Okay, let's have a look at this. Okay. I am an international student. Can I continue to work? You can continue to work after you finish your studies only if you have already applied for a work permit or you're starting a new study program. But this is the, you know, this does not, let me show you the source. It will be easier. Who can study? Okay, who can study? We'll look at 186. Okay, let's look at 186 here about student. A foreign national, a student, a foreign national may work if first on campus, if they are full-time student on the campus, okay, and they are for a period, they hold a study permit to study at that university. So they need to have a study permit, obviously. And they're full-time student, they're on campus, they have a study permit, one. Okay, then we have off-campus, okay, off-campus. They're holder of the study permit. They are full-time student and the program for which they are enrolled is post-secondary and so on. Okay, 20 hours, 40 hours a week. This we know. Okay, and then we have if they are or were holder, they can work without a work permit. If they were or if they are holder of a study permit, they have completed their program of studies, they meet their requirement that they were on V, that they were full-time student, and they have applied for a work permit before the expiry of that study permit. That and a decision has not yet been made in respect to this application. So W here is being on implied status. Okay, so you finish your studies. For 90 days, you are a student. You can work off campus. It says you're allowed, you are a student. You applied for a postgraduate work permit. You become, after 90 days, you are on implied status. Implied status means you are still a student. As long as you are a student, you can work off campus for 40 full-time until you get a decision for your post-graduation work permit. So this is the exact information here. What you've already applied, you can continue to work after you finish your studies if you already applied for a work permit, which is the postgraduate work permit. Okay, so this is generally no, but yes, if you need to be entitled to a postgraduate work permit. Okay, you could still apply and not be allowed. Then you would still be under implied status and you could stay in Canada under implied status. Okay. Okay, so that is my, if they did not apply for a work permit, they cannot work. Yes, absolutely. Because then after 90 days, they lose status. They have no more status. Okay, so for 90 days, they are able to work. After 90 days, they're out of status. They have to leave Canada. Question?
Yeah, I have a question. So like, I'm kind of confused. So let's just say, can somebody come into Canada with visitor visa and study at a school which is 4 months long? Do they have to tell that to the officer, or do they don't need to tell that because they don't need a study permit?
They don't need a study permit, but when you enter Canada, you must answer truthfully questions that are being asked.
Okay, okay.
If you come for business, you say, I come for business. You come to study, I come for study. You come for a holiday, you want to visit Niagara Falls, you say, I'm coming for a visit, or I'm seeing family, or I'm here to give birth to my child. Look, I'm pregnant, I'm 8 months pregnant. You have to declare the purpose of your stay.
Okay, and I also want to say this, let's just say if you're a visitor, and can you apply for a study permit within Canada, or you need to be doing like courses that you have to finish before you start the main program?
You have to have a letter of acceptance that the study you're doing without a study permit are conditional to the acceptance of your full-time program.
Right. Okay, and can you apply for a study permit in Canada? like if you're a visitor and you decide to study more than 6 months, can you apply for a study permit in Canada, inside Canada?
If the studies you are about to do are a condition, because if you're only a visitor, you want to enter McGill University, you cannot from within Canada.
Okay.
Okay, as a visitor, you cannot apply for a study permit inside Canada unless, and those were the conditions here, let's go back to this PPT here, unless you're a minor, let me see where is that, if they are at preschool, primary and secondary school, visiting exchange at DLI, they have completed a course or program of study that is a condition for acceptance at DLI.
Can they make an
Okay,
application, for example, in the embassy in New York, and then when it comes, when they issue the visa, he can send them the passport, come back, and then leave at the borders and come back. What about this?
Yeah, that was actually all application today are done online. So the person is in Canada, applies online with an address outside Canada.
Even with an address inside Canada, what difference would be?
Then you cannot apply online. It will say, what is your status? So then the computer stops you from going further. So then you have.
When they issue the visa, they will ask him to submit his passport. He would send it by DHL, get it back.
No, not anymore. You're just being issued a PDF letter that it says present this at port of entry.
Yeah.
And then at port of entry, you show your passport, and then the study permit is issued. So what people will be doing is what we call flag polling. So they will leave Canada by land, they will re-enter Canada, and then they show their passport, the letter of acceptance, the letter of study permit, and then CBSA then will issue the study permit. Then you enter Canada as a student.
And the CBSA has no problem with this. You are legal.
No. That is a standard procedure.
Gary,
Yes, hello.
If somebody is a destitute student, can they continue working even if their post-graduation work permit is expired?
Well, to continue working, you must have a study permit. You must have a work permit, sorry.
Yeah, but isn't there an exception in case of a destitute student?
But the destitute student, yeah, there is an exception. The destitute student is a student. The person has a valid study permit, but is destitute, therefore is requesting on top of the study permit, a work permit to allow the individual to work. So normally the work permit should be issued, I would think, for the validity of the studies.
Okay, thank you.
Good, okay. Question, will the work experience during implied status be counted for their PR application under CEC? No. Okay, that is clearly stated in the regulation for Canadian experience class. Working with a student status, experience will not be calculated. Okay, so what do we have? So study in Canada, what do we have here? A foreign national may not study in Canada unless authorized to do so. Okay, and we have the exceptions, okay? Minors in Canada may study, sorry about this. Minors in Canada may study without a study permit if they accompany a temporary resident that has a work permit or a study permit. Okay, so this is what we have. Just briefly, I want to show that is the people who would fail to comply, section 44, then, and people would be removed from Canada. I just want to show, I want to leave those study permit. This we know about the invalid postgraduate work permit. I think I have spoken about this already. it's 90 days as a student, but you can have an extra 90 days to apply for the postgraduate work permit, even though, but you're no more a student. Okay. I want to say who may, yes, this is what I want to say. Who may study in Canada without a permit? Diplomats, foreign representative, certain member of armed forces, duration of the program of less than 6 months. Okay. But the exception, this is it say, a foreign national may apply for a study permit for a course of program of studies of duration of 6 months or less. What's the advantage? You already have a study permit, then you can apply for a study permit inside Canada, no flag polling required. Okay, so that's the big difference. Okay, so I want to leave this. Okay, I want no permit required, 6 months or less, foreign diplomats, armed forces, children. And you do have here, maybe you should screenshot this one about who may apply for a study permit from within Canada. Some of you are asking. So it depends. Okay, there's a number of exceptions here that you can see on screen. So take a screenshot because there's very few minutes left. And I guess you want to hear about Quebec. So Quebec, can you upload the slide that you use every day and today, yesterday and today? Yes, it's almost harassment, this request. I don't know how many times today, really. So how many times the last 10 days, okay? Okay, Quebec, okay, Quebec has, let's, maybe I should let's get rid of this, okay, and I'll be speaking to you. Okay, stop sharing. So you have to look at me. Okay, Quebec has signed an accord. What is the concept? Yes.
Just a quick question before we move over to Quebec. For ESL, do they also need study permit?
No, if it's less than 6 months, no.
So, but if it's more, let's say 7 months, definitely they do need one, right?
Absolutely.
Okay, thank you.
Welcome. Quebec, well, first let's start with the Canadian Constitution. The Canadian Constitution, section 95, says that although we are in a federal government, a federal system where you have a central government, federal with a certain number of powers, and the provincial has other type of powers, we have section 95 of the Canadian Constitution that says that both agriculture and immigration are shared jurisdiction, which means that parliaments, provincial parliaments and federal parliaments may make legislation about immigration. Okay, so that is the source. That explains why not only Quebec, but all provinces are able to deal with immigration matters. It is allowed by the Constitution. Okay. And then there is the Immigration Act that says, section 8, that says the federal government may enter into agreement with any provinces. Okay, so Quebec, in the 1970s, entered into an agreement with the federal government, according to the Constitution, that says we want in Quebec more power. We want to deal with selecting people who are destined to Quebec, whose destination is Quebec, but according to specific selection criteria that we will establish. So basically, what we call the Quebec Accord gives to Quebec, which is very similar to the other provinces, the selection rights to establish its own selection criteria and decide who will fit the selection criteria of Quebec. So Quebec has designed a number of programs. The particularity of the Quebec Accord compared to the PNP is that PNP deals only with economic permanent immigration. Okay, so you have skilled workers, semi-skilled worker, entrepreneur, agriculture, farmers. But the Quebec Accord goes far beyond this. It deals with, yes, permanent resident, economic immigrants. So we have skilled workers, we have an equivalent of Canadian experience class, investor program, entrepreneur program, and those are all economic. But also Quebec does selection is involved with shared jurisdiction with the federal government, family class. Okay, so an undertaking is the eligibility side is done by the federal government, and the financial assessment and the undertaking itself is signed with the Quebec government. Okay, and the agreement says that any individual wishing to settle in Canada permanently before coming to Canada must apply to Quebec and must obtain a certificate of selection of Quebec, this famous CSQ. Okay, that is an essential component of the Quebec agreement, and this is why you see when you read all the various classes, it says the Canadian experience class, the federal skilled worker, and so on, is for people who wishes to settle in Canada except Quebec. Why? Because if people wishes to settle in Quebec, they must go through the Quebec immigration programs and be selected by Quebec by obtaining a CSQ. So Quebec has sole jurisdiction over the selection process. The admissibility requirements is done by the federal. Of course, a permanent resident visa is issued is a PR, is a permanent resident visa. It's valid for all Canada. Okay, a Canadian dollar is valid in all provinces. Okay, so that's the same with a permanent resident. Okay, so once a Sikh and his family live outside, once a person has become a permanent resident, has landed in Canada, that includes Quebec. Quebec is in Canada, not to forget. Okay, once a permanent resident has landed in Canada, that person is a permanent resident of Canada, and the Canadian Charter of Rights guarantees mobility rights. That is valid for Manitoba, that is valid for BC PNP, that is valid for New Brunswick, and that is valid for Quebec as well. So any individual in Canada who is a permanent resident can move anywhere. There is not a single province who could force the permanent resident to stay in that province and lose permanent residency. That does not exist, and that cannot affect the renewal of the PR card or the acquisition of citizenship. Okay. Okay. If you were told by a previous professor you can be held for misrep. How do you establish, though that is not at the entry to practice exam, but it is extremely difficult to prove that the change of intent after you landed in Canada, that actually it's not a change of intent, that the intent of not to reside in a certain province was planned and can be documented. Okay, CBSA would have to investigate and obtain strong evidence that indeed the individual did plan all along to settle in a province other than the one originally destined. So that would be misrep indeed. But so far, the Canada-Quebec Accord exists since 1978, and PNP program exists since the 70s also. I have yet to see a case of removal order because of a change of the destination in a province. Okay, because that's a tough job to demonstrate. And I have seen over the last, since 1980, I have seen hundreds and thousands of Chinese investors applying through the Quebec Investor Program and not settling in Quebec. None of them has been accused of misrepresentation. Okay, because it's very, very difficult to proceed with this with a removal order. this to say, back to the Canadian Charter of Rights, you do have mobility rights. Okay, so usually, and as I said, not only Quebec, any PNP program, there's been no misunderstanding about this. Okay, so let's say the person has not received PR, just CSQ, but because of a dying relationship, spouse, children live somewhere else, but the applicant still live in Quebec. Would that affect his PR application? The individual, if there is a breakdown in the relation, it is a duty of the principal applicant to inform the visa office that there is no more dependent in the application. Okay, so that is enough because everybody is a foreign national. So far, the PR application, I understand, has not been processed. So then it is the duty of the principal applicant to declare that I'm coming as a single person. I have a breakdown in my relationship. I do not live anymore with my spouse and my children, if that was the case. Okay. Can you explain the difference between the MIFI and MIDI? It's the same. It's just that Quebec immigration change names all the time. Okay, I've worked. One day, I think I would like to have a list of all the names of that department. It has been called MCCI, MICC, Quebec Immigration, MIDI, MIFI. It's very difficult to follow, but it's always the same department. Okay, it's the Quebec Immigration Department. It is the only department that the headquarters is in Montreal instead of in the capital city of Quebec. Also, back to the agreement. The agreement is also about temporary residency as well, and refugee. Quebec select refugees according to its own criteria. Quebec this is a shared jurisdiction for both temporary workers and students. You need the approval of both government to process an application for a student or an application for a temporary worker. So LMIA is jointly approved. Student, you have a CAQ that is issued for student, a CAQ issued for temporary workers, and you also need the approval of the federal government to issue the study permit or the work permit. The only field that is not dealt by the Quebec government are visitors. Okay, visitors. What else? Oh, just one question before we finish. You will have a question. It's often there, this question, about to practice in Quebec with the Quebec government, to represent a client to the Quebec government, you must be registered with the Quebec government. So first, so listen carefully, I have only 1 minute left. You must be member of the RCIC. That is the first requirement. And then you must apply to be registered with the Quebec government. Quebec government will require you have a company registered in Quebec, you have knowledge of French, and you successfully passed a knowledge test of about Quebec immigration regulation and legislation. Okay, so the question at the entry to practice exam is, can I be outside Quebec and represent a client to the Quebec government? That depends how it is worded, okay? But if the person is registered with Quebec, the answer is yes. You don't have to reside in Quebec to represent a client with the Quebec government, but you must be registered with Quebec. Okay, for instance, I don't live in Quebec, but I am registered with Quebec. Then that qualifies the requirement to represent clients to the Quebec government. So there is usually a question about Quebec on this specific issue. Okay, so that is all for today.
Jerry?
Yes. One last
sorry,
question.
I know the time is over. Would you give more explanation about the knowledge test? It means it is another EP exam?
Sort of.
Yeah. And who take that exam? The Quebec government or?
Yes, it's with the Quebec government.
Right.
You speak French, Mohammed?
Not too much.
Okay. No, I thought you were interested to apply for the Quebec. This is what I was asking.
Yeah.
Okay. 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 So so yes, it is the exam that is prepared, delivered by the Quebec government, specifically focused on Quebec legislation, Quebec Accord, and the various Quebec programs. So it's a knowledge test. It's a proficiency.
It's not about immigration, that test.
Yeah, it's about Quebec immigration, absolutely.
Yeah. Thank you. Thank you so much.
Welcome. So have a good weekend. Have a good quiz. I see you on Monday for this very last class. Mark 2, Mark 3, and miscellaneous question. Okay, have a good weekend. Take good care. Be careful. Wear your mask.
Bye, everybody.